All right, the Joint Revenue Committee will please come to order. Eve, will you please take the roll?
Senator French.
Here.
Senator Ide.
Here.
Senator McEwen.
Excused, he's on his way.
Senator Pappas.
Here.
Representative Baer.
Here.
Representative Byron.
Here.
Representative Locke.
Present.
Representative Northrup.
Here.
Representative Oakley.
Here.
Representative Storer.
Here.
Representative Strock.
Here.
Representative Swanitzer.
Here.
Co-Chairman Harshman.
Here.
Chairman Beitman.
Here.
Mr. Chairman, you have a quorum.
Thanks, Eve. Opening remarks, we have a lot on our plate the next couple of days, so we'll probably just get to work. Welcome, everybody. Thanks for coming to 2 days of action-packed revenue. Mr. Co-Chairman, do you have any comments before we drive the bus?
No, just a lot of good little bills.
A lot of good little bills. Looking forward to hearing everybody's input on these. Okay, approval of minutes. Eve, do you have the minutes from the last meeting?
They should have been included in your packet.
Okay. Is there?
Mr. Chairman,
Move
move approval.
Okay, moved by Pappas, seconded by Storer. Any discussion? Hearing none, all in favor say aye.
Aye.
All those opposed? Okay, the meeting minutes from last meeting have been adopted. Next item up on our agenda is government property discussion, bill draft 25 LSO 362, government-owned lands. And Josh Anderson, our staff attorney, senior staff attorney, will walk us through the bill and give us a little background on that. And here comes Brenda Henson too, the director. Welcome. Good morning.
Morning, Mr. Chairman.
What do we have here?
Josh Anderson, LSO. So this bill draft is on the agenda. There was a recent Supreme Court decision by the Wyoming Supreme Court. And just briefly, and Brenda might jump in here, but the case came out October 9th, or the decision came out October 9th. That was the Uinta County assessor versus the state. There were a little over 3 acres of land that was state hospital land, and it's had a gas station on it since 1999. And the Uinta County assessor sent a tax assessment on the property in 2021 and 22, and the case came out of, they challenged the sale or the property tax on that property in the 2022 assessment. The state essentially argued that because they were required to lease those lands to raise revenue for the hospital, that those should be exempt, even though the gas station is not a governmental purpose. And so the exemption is if property is owned and used for a governmental purpose, it is exempt. And then the statute provides some examples of what is not owned and used for a governmental purpose. So that's kind of setting the background. Let Brenda jump in with any additional comments real quick.
Good morning, committee. Brenda Henson, Director of the Department of Revenue. Welcome back. It's great to see everyone. It's been a busy few months, a lot of things going on in tax world. And one of those is this Supreme Court case. This committee, more than anyone else in the legislature, understands and recognizes the challenges of governmental exemptions. And because you've heard over the last decade, at least 3 times, we've discussed governmental property tax exemption and what does this term used primarily for a governmental purpose actually mean? Well, you've heard testimony that historically county assessors, it's hard for assessors to get county attorneys to back them on valuing governmental property because the presumption is with governmental property that it's exempt from property taxation unless the assessor proves otherwise. So in this particular case, the Uinta County assessor had a property where she had historically valued that truck stop, but not the land that actually was the parking lot for this truck stop. So then she took it as a important piece to clarify, and she taxed this land to the state of Wyoming. State Lands is the entity that appealed that valuation, and that discussion went all the way to the Supreme Court. So I'm hoping that many of you have had or will have an opportunity to look at that decision. But basically, it discusses on page 3 of that decision, in 1955, the legislature passed a joint resolution proposing to amend the Constitution to exempt government property from taxation only when used primarily for a governmental purpose. The reason for that was to clarify that the taxation of such property was important in order that non-governmental entities weren't the only ones paying their fair share of the overall tax burden. That if that land was being used, land and improvements. Now, when we turn to 3911-105 in our exemption statutes, it states property owned by the state of Wyoming and used primarily for a governmental purpose exempt from taxation. And then it goes on to list what properties are not used for a governmental purpose. And one of those is improvements placed on state lands by lessees for private or commercial use. So the truck stop had been taxed historically, except for the lands. The Uintah County assessor assessed those lands, and the Supreme Court came back with a decision that said, based on that constitutional framework, that those lands are taxable. Now, what made this really important was that one of the arguments that the state of Wyoming, state lands used was, we currently have millions of acres of land leased as grazing leases. And if this case were to find this parking lot taxable, what would that mean for all those state grazing leases? Well, because of that, they were very clear in this decision. The state of Wyoming argued the board leases millions of acres of state land to private entities who conduct commercial businesses on the land, grazing leases. And the court stated whether such an exemption should be created is a policy question for the legislature, not for this court. Under the plain language of Wyoming Statute 3911-105, the exemption the state argues for does not exist. And quite frankly, county assessors across the state have looked to see how they could defend themselves historically, exempting all that land, have not been able to find any guidelines on that. So it hasn't been taxed historically. But right now, based on this decision, county assessors across the state are required to value all lands that the state of Wyoming leases to private entities for non-governmental purposes. Now, when this decision came out, we met with state lands, and it's important to know on grazing leases, just a reminder of how we value those lands. We value those lands based on their ability to produce. Now, we're making an assumption. We recognize the challenges with assumptions. We're making that assumption that if it's a grazing lease, it's used for grazing purposes. So what we did is we took a shapefile, GIS shapefile from state lands where they have mapped all of their grazing leases. We overlaid that with, and I believe you've got these materials in your packet. We overlaid those state leases. We did not put it, this side is up, so this is up. So if you're looking at this map, this is the state of Wyoming, and the blue identifies all the grazing leases in the state of Wyoming. Now, this equates to a little over 3.4 million acres that now become taxable. Now, as you all know, in property taxation, everything is valued as it exists on January 1. That's the assessment date, the lien date. We tax it to the owner of record exactly how it exists that day and with the statutes that exist on that day for the following year. So for 2025 property tax year, this puts the burden on county assessors to value this land. Now, as I stated, we're assuming these grazing leases are being used for grazing. What we were able to do at the Department of Revenue is take the productivity information. Department of Revenue has that statutory responsibility of doing an agricultural land study. We look at the soils information from the NRCS, and we identify what those values are. We do a value range, a minimum value and a maximum value, and then county assessors pick the per acre. What does that mean applicable to this case? That means that the Department of Revenue was able to come up with an estimated fiscal note of a little shy of $3 million if we use the maximum value per acre as rangeland for the 3.4 million acres. It will cost the state of Wyoming approximately 3.4 million, less than 3 million for the actual taxes on those. And the Director of State Lands did ask the governor in his supplemental budget for that $3 million to pay those taxes, because it's important to note that most of those grazing leases do not have any provision that the lessee is responsible for any property taxes, should there be taxes. Now, the State Board of Land Commissioners will be considering that lease language. So we have the ability to value the agricultural land for the 2025 tax year, but you have before you a bill that considers exempting that land owned by the state of Wyoming. Now, I should mention that the Ag Interim Committee also entertained a bill and voted to sponsor a bill that would exempt land that the state of Wyoming owns and is leased to a private entity, but only for 2 years, with a requirement that there be an interim study on the taxation of governmental lands in the future. So we have that piece of legislation that's already out there. Obviously, it'll go on to the body. One of the questions is also, there are other leases besides grazing leases, obviously. But if there are commercial businesses on those lands, county assessors are already valuing the improvements. Remember that improvements is anything other than the land. So there's structures, personal property, all of those things that are owned by those private companies that are leasing land from the state. Those are already being picked up by the county assessors. Now, in those instances where it's commercial, county assessors can add that land to the assessment roll for 2025. But what we're looking at doing is automating this process for all these grazing leases for county assessors across the state, and we're able to identify those leases, map those leases, calculate the per acre values, load those into the computer-assisted mass appraisal system, and then upon recalculation, whatever the per acre value is that that assessor chose for their county that's within the min-max guidelines, that will be applied just like it is to all their other privately held producing land. I know that's somewhat long-winded, but there's a lot of moving parts with this Supreme Court decision. But I'd be happy to answer any questions that the committee may have as what I may have missed on going forward.
Thank you, Director. Any questions? We'll start down here. Representative Zwanitzer.
Thanks, Mr. Chairman. I missed it. The Ag Committee has a bill for just grazing lands or for across the board, any commercial lease? If you know.
Mr. Chairman, Representative Zwanitzer, I believe it's for across the board, but it specifically does say leased lands in comparison to the bill that you have before you today.
Follow-up?
Thanks, Mr. Chairman. So would that include anything we have a 99-year lease for? I mean, not just grazing leases, which can be 3 to 5, but any kind of long-term lease the state enters into on state land would be exempt.
Mr. Chairman, Representative Zwanitzer, that's correct. So you've got cabins on state land that are also included in this decision, wind towers or wind turbines. We do have some mineral. When we get into the weeds a little bit, there's a few things that we need to keep in mind. Wind farms are already being valued locally by county assessors. How that land is treated is done locally. When we look at mineral leases, we also know that our Constitution exempts taxation of surface. Basically, wherever that point of valuation is, there's a constitutional provision that severance taxes are in lieu of the property taxes that would be on the surface. And so we've got an exemption there. The other thing that we have with state leases is, in some cases, we've got multiple leases on the same land. So you may have a grazing lease and a mineral lease, but we will be capturing the grazing leases with this process that I've identified. But great questions.
Representative Bear?
Thank you, Mr. Chairman. Thank you for being here, Director, and imparting all this knowledge to us about the Supreme Court decision. I'm curious about the Supreme Court decision, if they took into account what the funding issues will be or impacts will be on school funding, since, they have weighed in on school funding repeatedly. And here we have, a lot of these sections are school sections. My assumption is that since the school foundation is the benefactor, basically the owner of those properties, that it would be the school foundation part of our government funding that would have to meet those obligations to the county. And although it would go back to the school, a great portion of it, some of it would be sifted off to the county and local governments. So was that accounted for in the Supreme Court decision at all, or discussed?
Director?
Mr. Chairman and Representative Bear, so the lands are still managed by the state lands and the state Board of Land Commissioners. And so all of those lands, while it is true that the schools, whether 12 mills to the school foundation, that estimated fiscal note of $3 million includes all of that for the grazing leases. Now, for most of the commercial, there's already provisions in those leases that state that the lessee shall be responsible for any taxes. That's pretty common verbiage for any governmental entity that would say, should there be a property tax incurred, the lessee's responsible for those taxes. And so I don't believe that there's any concerns there.
Follow-up?
So since I think you mentioned that we don't have those provisions in these grazing leases, so currently that would create some sort of impact there, but it wouldn't be the state responsible. If we pass this bill, should the bill not pass, the state would be responsible.
Mr. Chairman, Representative Bear, yes, and that is why state lands requested $3 million on the supplemental budget request. And I believe the governor has approved that request in his supplemental budget. So the legislature will definitely see that $3 million impact for consideration during the session.
Senator Ide.
Thank you, Mr. Chairman. Director Henson, it seems surprising to me, just a question, after 134 years since statehood, this is just raising its head and getting challenged. Can you comment on why? I mean, it seems like this is awfully strange that it's just now coming to surface. Thank you, Mr. Chairman.
Director?
Mr. Chairman, Senator Ide, as stated, having administered property taxation since the late 80s, I can tell you that this conversation has been one that county assessors across the state have struggled with. I will tell you uniformly across the state, none of the county assessors over the last 3 decades have valued grazing leases for taxation purposes, and that these lands and the question of when the government leases out lands to an entity for a non-governmental purpose, should those be taxable? County assessors across the state and the Department of Revenue believe that that was a question the legislature needed to answer, as did this committee. And that's why we had interim topics three different times, but just never got a bill in front of the legislature for everyone to consider. Because bottom line, the Constitution requires that governmental lands be used for a governmental purpose in order to be exempt. And we have not, as a legislature, defined what is a governmental purpose. So now the courts have demanded, I state, basically demanded that administratively we define that.
Okay. Director, I have a question. So in 3911-105, there's almost identical language dealing with the United States. Does this affect that as well? Since it's identical language. So does this affect federal grazing leases as well with this ruling?
Mr. Chairman, that is being researched. Federal land is a little different. So we talk about how states have the authority granted to them by the federal government. Okay, taxation is one of those things that has been given to the state of Wyoming to tax. So that will be explored. We do not have clear guidelines for 2025 tax year as of yet. But that relationship is very similar to where the legislature grants the authority and responsibility of counties. They have the authority granted to them by the state. The federal government grants authority to the state of Wyoming for taxation. So I believe that that will be explored, but I don't believe we'll have an answer for the 2025 tax year.
Okay. Yes, Representative Oakley and then Co-Chairman Harshman.
Thank you, Mr. Chairman. Just really quickly, I'm having trouble getting on my legislative email with the service down here. Can you give me the citation or the name of the case? I'm just,
Sure, Mr. Chairman. The case is State of Wyoming versus Uinta County Assessor. It's 2024 Wyoming 106.
Mr. Co-Chairman.
Thank you, Mr. Chairman, Director, and Josh as well. Reading your staff notes as well, I mean, and I didn't know about the other committee's bill, the Ag Committee bill. I'm just trying to think what's the best, vehicle moving forward. And if we pass this bill, we're probably not done with this issue today. This committee's not done. Is it maybe better to just let that Ag bill maybe kind of get behind that? So your opinion on that, please. Thank you, Mr. Chairman.
Sure, Mr. Chairman, Mr. Co-Chairman. As you noted in the staff comment, this language of primarily for a governmental purpose is not only in the state lands, which the case was directed towards, but also the federal lands and county lands and city lands. And so, and as Brenda noted, we have had that as an interim topic before of trying to make those a little more uniform so that it is easier for the county assessors to administer. And so, as you noted in the staff comment, I would be likely recommended for the committee to consider that as an interim topic for next year. I don't know a whole lot about the joint ag bill, and Brenda, I believe, or Director Henson was there, and she may be able to comment a little more on that.
Bottom line, Mr. Chairman, Mr. Co-Chairman, the Agricultural Committee looked at land that is being leased for a non-governmental purpose, and then basically put a 2-year repealer at the end of 2 years, and also stated that there would be an interim study to define what is a governmental purpose during that time period. Now, their intent is to backdate that to January 1, 2025, so that it would be applicable for the 2025 tax year. It's a challenge. As we've all talked about, assessors across the state have to get assessment schedules out no later than the fourth Monday in April. And so we really didn't feel the Department of Revenue as that supporting arm and county assessors that we could just wait. Now, we do have the ability to wait until after January 1 because, first of all, I need to know which leases are in place on January 1 of 2025 in order to know which lands are taxable for the 2025 tax year. Should the legislature move quickly on an exemption and stating that that would be for 2 years until the legislature defines that, it's possible then, we were going to load these assessments into the CAMA system, automate that process for county assessors. When we load them, we can just as easily back them out of the CAMA system prior to that April assessment date mailing. But should it be the will of the legislature? Because I think it isn't as clean cut as just, let's just exempt everything that the state of Wyoming owns, because I think that there is some effort there to say, wait a minute, Is it fair that these lands that aren't being used for a governmental purpose should not be paying taxes? I think that there will be a very robust discussion related to the taxation of these lands. And so the county assessors and the Department of Revenue are struggling a little bit this year. But we'll definitely do the best we can. But should the legislature backdate an exemption, we can administer that as well. But I can tell you that we are working as if they will be taxable. That's our plan right now, that we're planning to tax them for 2025.
Representative Storer.
Thank you, Mr. Chairman. Director Henson, if you'll just give me a moment here as I think through this a little bit. So one of the issues I think for us to decide is to recognize that there's the state and then there's the beneficiaries of the trust. And those are two different entities. And to your point, that the argument is that the beneficiaries of the trust are the ones that would benefit from the taxation, even if it's the state that's paying for that. In that, that's what the Constitution requires in terms of equal and uniform and full value. I guess my other question, related to that is, I was thinking about reading this last night, who's benefiting and whether the state is actually charging full market value for the leases that they have that would be reflected, that value, were this to be private land that's leased. So if you have a truck stop down the road that is on private land and that private land is paying property tax on the land, then the lease to the truck stop would be reflected in that, versus right now at the state level, that the cost of that property tax may not be put in there. So the question of is the state actually charging full market value for its leases, and how to think about that, I guess is one of my questions. Thanks.
Mr. Chairman, Representative Storer. So again, talking about the fairness issue for lands that are owned by the government, but being used for a non-governmental purpose. I think that you hit the nail on the head, and that's where, just in fairness to those competing truck stops. If I'm a privately held truck stop and I'm paying taxes on my entire property, including the land, and I'm in competition with a truck stop over here who just happens to be leasing from the state of Wyoming, and historically those taxes have not been collected on that land, that's a competitive concern there. Now, I will tell you on the lease itself, obviously, we don't have any information on what those leases, the dollar amounts of those leases, those are private leases, although it's a governmental purpose. Now, for taxation, we're going to be treating those properties, it doesn't matter to the county assessor whether they're privately held or owned by the government. The appraisal process will be the same. For grazing land, it'll be assessed just as if it were grazing land held by a private owner. I will tell you that state lands and the leases have not contemplated the taxation piece historically. So grazing leases have not accounted for possible taxation within those amounts of those leases, just as they have not stated that should there be a tax burden that's passed on to the lessee. They haven't stated that in those leases. So that's why we're in the situation we are today, where state lands is looking at paying those taxes and then exploring how do they treat these lands in the future. Now, should the state of Wyoming deem in the future that somehow those leases that are to a private entity are somehow qualify as a governmental purpose, those taxes, will be inconsequential. So, but it's only if they become taxable. I do know that there are numerous leases across the state, whether it's owned by the state, owned by the county, owned by the city, where they are leasing land out to a private party, and those leases typically have a provision that the lessee is responsible for any taxes. The lessee also has the ability to appeal those taxes if they feel the fair market value is incorrect. So we've kind of got many moving parts on this, but specific to the grazing leases, which seem to be the more, it's just vast in the number of acres and the number of lessees that we're talking here. It's just that that seems to be the most challenging as far as workload to get these on the assessment rolls for 2025. The other commercial leases, I think assessors handling will take care of that.
Representative Wanitzer.
Thanks, Mr. Chairman. So the Ag Committee is putting forth 3 million just to cover grazing leases, but that's not to cover the gamut of all the other, we just treat that as an exemption. I mean, it certainly seems not to be fair, equitable, and just when the state's paying off the taxes for certain people who are leasing land for one purpose but not for another, as much as I love ag exemptions on everything. Is that correct? And I guess my overall question is, do we know what it would cost to pay the taxes across the board for everyone caught in this situation, not just grazing leases?
Mr. Chairman, great question, Representative Swanitzer. The only thing I would state is that the majority of the leases that are not grazing leases have a provision that the lessee shall be responsible for those taxes, if there are taxes. And so, most of those are accounted for. It's fortunate in that state lands actually has a separation of grazing leases, which is the map you saw, and then other special leases is what they call those. A county assessor is already valuing the improvements on those leased lands because the statute says that that's not a governmental purpose and has never been interpreted as such. So county assessors will now just include the land in the valuation with those improvements. So I think it will be addressed, but I mean, this is new. We know that we will be educated and learn more going forward.
Yeah, follow-up.
That might actually be for Josh, Mr. Chairman. The staff comment says right now the exemptions for federal, county, city, and school district lands are all of similar language in the statute. So if we had a lawsuit in any of those, the belief is that would also fall. And I guess my overall question is, this is a pretty large issue beyond just grazing leases or, I mean, it's going to affect everything unless we solve it. Perhaps the question then is, our chief executive offered any guidance or state lands on interim study? I mean, I don't want this committee to piecemeal and ag to piecemeal and we all just kind of hold it together. We need to do something for 2 years, but what's the greater plan, either legislature or executive branch, on how we're ultimately on the same page fixing this?
So Mr. Chairman, I guess, I mean, I think the case was specific to state land, so that's why this bill and the ag bill also were specific to those lands. But I think there is a bigger topic that should be addressed. And I do think, it'll take some time to because they are all different. They all are related to governmental purpose, but they're all structured differently. And that's why it has been in front of the committee a few times in the last several years. But it's also, pretty complicated issue. So that's why the committee's never, I think, come forward with any fix, because I don't think there is necessarily an easy fix to it. Director
And if I may, Mr. Chairman, Representative Swanitzer, when you go to 3911-105, so under federal, it says property owned by the United States, the majority of which is used primarily for a governmental purpose. And then federal, it says the following property is not owned and used primarily for governmental purpose. And the very first statement is improvements placed on federal lands by persons for private or commercial use. It's already there, but it says improvements. We go to the state, it says improvements. The lands have not been contemplated. They have not been considered until this case came down the pike. Now, when we go to county government, the statute simply says property owned and used by counties primarily for governmental purposes. We don't have any of those clarifying things that say this is not a governmental purpose. We don't have that for counties. And then for cities and towns, we have just the opposites. For city and towns, it states used primarily for a governmental purpose, including, and then it goes through this list of things for cities and towns that are a governmental purpose. Is the assumption that if they're not on that list, that they're taxable or non-taxable? Those are the questions that inquiring minds have wondered for decades.
Representative Storer.
Thank you, Mr. Chairman. Director Hinson, this does seem to be a bit of a quandary, especially in a place like Teton County, where we have high land values, but that may not be reflected in the state land leases that are currently ongoing. And in this case, I'm thinking actually more about the commercial leases. I can think of some notorious glamping sites and some storage sites on the 390 parcel that we all know so well. And that could be very significant in terms of what the state needs to cough up, or the lessee needs to cough up for the beneficiaries. Am I correct in thinking about that?
Mr. Chairman, Representative Story, it will be the responsibility of the county assessor to appraise all those parcels that are leased for a commercial purpose at fair market value for 2025.
Director, can we go back to minerals real quick? Something near and dear to my heart. Just so we're clear, this won't affect mining leases, oil and gas leases, because those are covered under the Constitution and the severance tax. That's what I heard you say. Is that correct? Is there any other, if we don't take any action, nothing's changing for the minerals industry, is that correct?
Mr. Chairman, that's correct in that up to, basically the Constitution puts the burden on the Department of Revenue to define how those surface lands shall be considered for that exemption, constitutional exemption. Our rules indicate 40 acre, up to 40 acres where that point of valuation is exempt. So whether it's the state of Wyoming or a private landowner for that surface land, those are already exempt. And so I just want to keep that in the back of everyone's mind, that we're not going to treat lands owned by the state of Wyoming any differently than we would if those were privately held lands. And if it's used for agricultural purposes and meets that criteria, it's going to be valued as agricultural. Now, I will say that for a private landowner, landowners are required to apply for the agricultural land criteria and to be deemed agricultural. There are 4 tests to being valued as agricultural. We do not believe that we have time to have all of those lessees apply for the agricultural classification. And we have deemed it that if it's an agricultural grazing lease, that the use is for commercial agricultural operation, and we're going to value it as agricultural for the 2025 tax year. Now, how we move forward, depending on the guidance that we get from the legislature, may be different if those continue to be taxable. But in trying to efficiently move forward in accordance with the Supreme Court decision, that's the path that we've chosen.
And if this bill were to pass, Josh, you can jump into this bill would basically keep the status quo of what we've been doing and keep that moving forward, correct?
I think so, Mr. Chairman. I think, the bill that's in front of you, it draws a distinction between lands and other property, including improvements. So it would clarify that the improvements are taxable, but it would exempt all lands owned by the state. So there may be some difference there. It may exempt some lands that are currently being taxed, like the land right underneath the gas station.
And the other piece of this, the bill that you have before this committee, is it does not have an interim study requirement, nor does it have a repealer at the end of 2 years.
So it's a policy choice for us to keep the status quo and just make it permanent, or if we want to work this bill, put a sunset on it or a study, we can certainly do that as well. But that's what we have before us committee. Okay, Senator Ide.
Thank you, Mr. Chairman. Yeah, you kind of just hit on what I was going to ask there as well. I just want to be crystal clear that this is, if we get some legislation passed, it's all academic pretty much, and then the county assessors don't have to start going through the books looking to how they're going to send a tax bill to the state effectively. So it all hinges on getting something done with the right, did you say it needed to be retroactive to a certain date? Just so we know all of that, so we can continue the status quo if we get the right legislation out here. Just want to make sure I'm understanding it completely right. Thank you.
Chairman Beitman, Senator Ide, yes, because the assessment date is January 1 of each assessment year. Right now, we have a Supreme Court decision that tells us that it's taxable, and it's effective right now, which means it's effective January 1 of 2025. Should the legislature pass any exemption for 2025, you'll need to backdate it to January 1. If it were dated upon signature in March, it's not applicable to the 2025 tax year. It's applicable to the year following, which would be 2026.
Thank you.
Mr.
Further
Chairman,
questions?
and
Yeah.
that is reflected in the current draft that's in front of you on page 4. It does say that it's applicable to the tax year beginning in January 1 of '25.
Thank you, Josh, and thanks for your work on that bill draft, putting it together for us. It kind of came up last minute. You did a good job. Thank you, sir. Any further questions before we open it up to public comment? Thank you. Thank you very much. All right, public comment. Good morning, Ms. Huxtable.
Good morning, Mr. Chairman, members of the committee. Dixie Huxtable. I am the Converse County Assessor, and today I am speaking just for Converse County. Our Assessors Association has not had an opportunity to look at any of these drafts today, so we do not have a status or an opinion on any of them. So this one specifically I'm talking to you about is Converse County. And just some information in Converse County currently. So when this came through, I went out to the SLIB board and looked at the state lands leases. I have approximately 808 current grazing leases. I also have 38 solid mineral leases, and I also have 427 current oil and gas leases. And while it's true about the exemption for the minerals, that exemption is if there's a producing well or mineral there. Some of these do not have producing for one reason or another, but they are leased to someone, but they may not be active yet. So from my perspective, this is a lot of work, and I want to get it right. I don't mind the work. I'll do whatever we need to do, but I want to be fair and equitable. So when we're talking about grazing leases, exactly what Representative Storer was talking about, in my county, when I look at my ag values, the production value, and I'm trying to find that number between the minimum and the maximum, I do a survey of some of my local ranchers. What is the cost of hay for the irrigated? What is the grazing AUMs for grazing purposes? And it does vary. And I do hear that if your deeded land is close to a government piece, you are not going to get the same rate of lease as you might otherwise because of the competitiveness between what they're paying for a state section or a BLM. So we'd have to take that into consideration when we're looking at where do we fall in that minimum and maximum. So it is important consideration. It's not for me to decide what that lease should be, but we do have access to those leases to see what the acres are, what the AUMs are, and to kind of do that look up, which I would do if you were deeded and you came in and you wanted to qualify for agricultural status because you're leasing your land to a third party. I'm going to look at that lease. Is it a marketable lease? And that you're not going to get to lease it for $1 a year and make that be a marketable lease in my county. So we're looking at what is the average market, and this state leases do play a part in it. And so it is important that you do take the time, I think, to work through this, not just for the grazing, but for all the other leases. We have land in Converse County that has a grazing lease and a mineral lease and a special use lease. It might have a wind turbine on it, or it might have some other things. So to say that the department is going to help us push out, for Converse County, I have all my state leases in my system, not state leases, state land in my system now. You can go to my map server, you can identify that parcel. So the state's going to help us by pushing out the state lands via a lease parcel grazing. But that grazing lease might have other leases tied to it. That's going to be something the state land board's going to have to deal with. And I'm going to have to deal with whether or not I've already picked up that mineral lease through a grazing or vice versa. And time is of the essence, as she said. we're working on it now. I can't wait till January 1st. And respectfully, I can't wait to make sure that the legislature is going to pass something. I got to be ready because I don't have enough time. And I think all the other assessors fall in that same category. Teton, maybe not with the minerals, but with the commercial. So we all have our own challenges, and we do ask for guidance. We, as Director Hinson has said, you've seen me testify about exemptions many times before. We have tried to assess, several counties have sent tax bills to the federal government for land that we believe is not being used for a governmental purpose, and we really quickly get a letter back from powers above our head that say, we didn't give you the authority to tax us, therefore you can't tax us. As Director Hinson said, that's being investigated. That's still being worked out with people with way more legal knowledge than myself. The fact that Uinta County Assessor took this on, I applaud her wholeheartedly, because many of us have tried, but as you know, we have county attorneys that don't always support us when it comes to difficult cases, and this was a difficult case, but she took it on, and the Supreme Court has now decided what is not a governmental purpose for that. So I applaud her for that, even though she's kind of put us all in a tailspin. I do applaud her for that, her hard work, because I do respect her for doing that. And for that, with that, I'd stand for any questions.
Yeah, Representative Zwanitzer.
Thanks, Mr. Chairman. I guess my overall question is, do you think this bill is the right way to go for the next, to put the precedent in effect without a sunset? That's what I'm struggling with, is this the answer we want to set a possible precedent, study it for 2 years, but then people are saying, well, it's been working, this is our new scheme, or should we hold off until we get all of our ducks in a row and make a uniform policy? I never quite heard if you like this bill or not.
Mr. Chairman, Representative Zwanitzer, the whole topic is difficult to work through. I think once you make a statement that says it's exempt, it's really hard to go back and change in the future. I've learned that from this legislative body over the years. It's very difficult to go back and move that back. If you've got the repeal in it so that it's only for a certain amount of time, it's a lot easier to know that you're going to have to make a final decision or maybe a different decision within those 2 years. I am a little concerned about how this will play out if it was to make everything just exempt. I do have concerns with it.
Representative Storer.
Thank you, Mr. Chairman. Thank you, Ms. Hexbill. I'm curious if you have an opinion. I know you're not an attorney, but the question of whether we can do this statutorily versus through a constitutional amendment. If what the court said to us is the Constitution says this should be taxable, the land should be taxable, but here we are coming in with a statute that's trying to essentially undermine that idea.
Mr. Chairman, Representative Storer, I do personally have concerns with that, with the language that's in the Constitution, where it says that used primarily for a governmental purpose, and we haven't defined that. That's not defined in this bill. This is just saying it is exempt. I think we haven't solved the problem that the court said you need to solve with this. And so I do believe that somewhere along the line, there's got to be some definition of governmental purpose. I think that's missing here, as we've discussed many times before. I do think there could be some legal challenges, and I'm not the lawyer, so I'll just stand back from that. But I've heard rumblings in the outside that, well, if it's exempt for that, they can do whatever they want with it and be competing against private enterprises and have an advantage. And so I think that would still yet to be heard. I don't think it solves the problem that the court put in your lap.
Any more questions? I have a question. You mentioned the scenario where, a company just picked up a mineral lease. They don't have any production going. Nothing's been done with that. You said that could be taxable in your county? That you'd be looking at taxing that?
Mr. Chairman, I do believe so, because we look at what is that exemption as it's written and in our rules is when there is a producing mineral on it. So if you've got the lease, but you haven't produced anything, then I don't believe the exemption applies. Those 40-acre exemptions change every year. And they are time-consuming workload for us to do. But an oil well that gets abandoned, plugged and abandoned, is no longer producing. That land is now taxable. Or a new well is drilled and producing, that becomes exempt. So those are moving, they're not, just because it's a mineral lease, it's automatically exempt. There's got to be some production there, in my interpretation of the rules.
So if I had a 640 acre coal lease that I just picked up, I would have to pay property taxes on that 640 acres? And what would that property tax be valued at? You'd value the state section? Fair
Mr.
market
Chairman,
value?
yeah, we would be looking at similar types of property that's got similar use, presuming that there's not an ag lease laying on top of it, because lots of those do. If they're not actively mining, there is an agricultural lease that they have the ability to lease it. And then we'd be looking at the agriculture use. That's the current use of that land. If it's not being used for ag and it's just sitting there waiting for a future development, then we'd be looking at what's the fair market value of coal land.
Would you value the coal, or would you value the goat pasture on top of the coal?
Mr. Chairman, not the coal, but that's an industrial land, okay? That is a different classification. So you'd be looking at that lands. And personally, there's not a lot of those out there to look at. We don't have a lot of that to look at, but that would be the process that you would follow.
Unless this bill were to pass.
Correct, in some form, yes.
Yep, thank you. Okay. Committee, we done with Ms. Huxtable? Okay, thank you, ma'am. Thank you for your time. Public comment still open. Come on up if you want to testify on this bill draft. Seeing none. Anybody on Zoom? Eve?
Yes, sir, Mr. Chairman. We have Jason Crowder from Office of State Lands and Investment.
All right, bring him in. Mr. Crowder, the floor is yours.
He is now online.
Good morning, Mr. Chairman. Thank you very much for letting me speak, and thank you very much for letting me do it remotely today. As usual, Director Henson did a great job of carrying my water. She's done a fantastic job of researching this issue, and we've done a good job of working together to understand what the impact is and the type of information needed to give you all the answers you need and to give us the marching orders we need to move forward, regardless of what the legislature does with this issue. I think what I can do is answer a couple of the questions that I've heard today, and then anything else that may come from the committee, and let you know what we're doing as an office and what the Board of Land Commissioners is currently working on to address the issue as well. So first of all, the Board of Land Commissioners will entertain some emergency rules at its December meeting on December 5th. And those are simply to provide a pass-through, as Director Henson mentioned, for any leases that may not have it currently in the lease language, that should there be any taxes assessed, that we're very clear that those be the responsibility of the lessee, because we don't currently have a funding mechanism to pay for that through our office. So as she also mentioned, some commercial leases already have that provision. We're going to be very broad in our emergency rule so that it catches everything, even those that may already have the pass-through built in. But it's very clear through all of our chapters of rules that those taxes, however they're assessed, if they're property tax, if they're an improvement tax, that they be borne or be the responsibility of the lessee. What's also important to note is that we can't just do that right now. A lot of these leases, as Representative Swanser mentioned, are in play. They're an existing contract, and we can't amend them without agreement by both sides. So we have to wait until those leases need an extension, or they are up for renewal, or at some period we have an ability to get inside the lease and make a change without that mutual agreement. As he also mentioned, grazing leases are for a period of 10 years. We have a certain amount of them, approximately 400 that renew each year, meaning that we can insert that provision into 400, but it's going to take you 10 years to get to all of them on a grazing scenario. Same with commercial leases, as Director Henson mentioned. Some of those are for 35 years, some are for 45 years. They're quite lengthy, so it may take some time before we're able to actually put that provision inside the lease and make the responsible party the lessee. So during that interim period, it will be the responsibility of the state of Wyoming to pay that tax pursuant to this decision. And that's why we've asked the governor for a supplemental request, and he's approved that to move forward with the legislature to put that estimate of $3 million in place. As everybody's mentioned that's testified so far, we don't truly know what the actual impact will be yet. And $3 million is a great estimate to start with, but that could change as we start talking about mineral leases, as we start talking about commercial leases, and get a better assessment of do the ag leases actually qualify for the exemption? Do they meet that 4 test criteria to get that reduced rate? So a lot of work still needs to be done, but $3 million was our attempt, working with Director Henson to make sure some money was in the bank to pay this to be compliant with the Supreme Court's decision. Another thing to note is that we are talking a lot about leases in this discussion. And one thing that Assessor Huxtable mentioned that we need to further vet is that definition of what is a governmental purpose. There's been some talk that even lands that are not subject to a lease may not be used directly for a governmental purpose and may be taxed, and they wouldn't have any reduction in any ag reduction, I guess, for the amount of tax that would be owed on them. And so we need to pay attention to that. And that's one of the things that I thought this bill did a good job of, is it didn't really consider the type of use, because maybe no use is a type of use as well. And it was a blanket exemption that we in our office could handle very easily. So with that, Mr. Chairman, again, thanks to Director Henson for carrying in my water, but I'm happy to answer any further questions.
Thank you, Mr. Crowder. Any questions? Representative Zwanitzer.
Thanks, Mr. Chairman, Mr. Crowder. 2 questions, unless you answer them differently than I expect. So all of the grazing leases, are they all on school trust lands? I guess is my first question. Or does the state of Wyoming have lands that we own outside of the state trust lands that you're allowing grazing on? And then second, all of that money in the bill, I'm assuming the $3 million is going directly into the school foundation account, if you know.
Mr. Crowder?
Thank you, Mr. Chairman. That's a really good question. And the answer is no. They're not all school trust lands, and they're not even all trust lands. So 86% of the lands we manage are tied to the beneficiary of the Common School Fund. 14% are tied to some other beneficiary. And then another, I think it's, I'm losing the number right now, but a few 100,000 acres are just tied to institutions, and they're not quote unquote trust lands. So when we are talking about the $3 million, we are going to pay that to either the Department of Revenue or the county assessor. I'm not sure how we'll break that down yet, but that's where it'll go, and they'll distribute it however the legislature's formula or the county's formula is currently designed. Where it will come from, right now, we have stated, as Representative Bear stated earlier, that the school foundation account should pay for school foundation or school trust land expenses. And so we've identified that as the source of the funding for the taxation, not necessarily where it'll go. Obviously, it gets distributed differently and not just to schools after that.
All right. Thank you. Other questions? All right, seeing none, thank you, Mr. Crowder. Appreciate
Thank
you.
you.
Eve, is that everybody?
We have 2 more people online.
Oh.
We have Brett Moline. I will admit him now.
All right, Mr. Moline.
There's a little bit of a delay.
Mr. Chairman, Brett Moline with Wyoming Farm Bureau Federation. Can you hear me all right?
We can hear you, we can see you. Good morning, sir.
Well, good morning to you. What a beautiful day up here in the high country of the Bighorn Basin. I would like to see this bill go forward. I would be open to putting a sunset date on it, much like the Ag Committee bill did. I believe it was Ms. Hanson mentioned that this is not the first time this topic has come up, and essentially nowhere is where we've gone with it. I think we need to look at this, do a study on it. Because one of the concerns, if we start making this taxable, what is going to be the net effect to not only to the state, but to the school trust foundation. And I think that's a question that we need to do a study on. So I would encourage this bill to go forward. And I would be all right if you put a sunset date on it. I would ask that you would put a sunset date on it in such, of a 2 or 4 year, that we would have the general session to make some final decisions. And with that, Mr. Chairman, committee, I would take any questions you may have for me.
Thank you, sir. Any questions? Any questions? Thank you, Mr. Moline. You're getting off easy this morning.
I like a good Monday.
All right. Have a good day. Eve, who's next?
We have Devin Brubaker from the Wyoming Airport Coalition.
All right, Mr. Brubaker. Good morning.
Good morning, Mr. Chairman. I appreciate the opportunity to join you this morning remotely. My name is Devin Brubaker. I am here representing the Wyoming Airports Coalition. I appreciate the committee's attention to this subject. Wyoming airports have some concerns regarding the Supreme Court ruling. If you had an opportunity to review that ruling, you'll notice that there was a citation to a 1976 case involving the Cheyenne Regional Airport. We would like to see this committee continue to study this subject, move forward with language that not only protects the state of Wyoming, but also the political subdivisions within the state of Wyoming that have lands. Our airports have vast amounts of acreage that are used for numerous reasons to comply with federal obligations. And we want to make sure that we're able to maintain our tax exemption status as applicable. When I look at Title 39, the section regarding exemptions that is subject to this bill, when I read that whole section, it appears to me that the committee, the legislature needs to look at the whole entire section and maybe start from scratch with it and look at how do we define governmental use. I agree with the assessors that for years we tried to come to a common understanding of what governmental use actually means, and I think that still needs to be done. I am not an attorney, so I would defer to attorneys in the room, but I also have concerns after speaking with our legal counsel that the bills as presented in Ag and this committee don't actually touch what is use, it touches what is ownership, and that there's concerns that that does not go with what the Constitution says about governmental use versus the ownership of such land. So with that, Mr. Chairman, I'd be happy to take any questions, but the Wyoming Airports Coalition is happy to be part of the solution and work with all the stakeholders to find ways to protect all local governments in this area.
Thank you, Mr. Brubaker. Any questions, committee? All right, seeing none, thank you. Appreciate your time this morning.
Thank you.
All right,
That is all we have for now, Mr. Chairman.
that's all our Zoomers. Okay, anybody else in the room before we close public comment? Okay, public comment is closed. Committee, what is your pleasure? We're going to move the bill, or are we going to just move on? Okay, it's been moved by Ide and seconded by French. Discussion.
Mr. Chairman.
Yeah, Mr. Cochran.
Mr. Chairman, I'd just offer an amendment, and I think Josh can work it in there, but it'd be on the last page. You see where the application in section 2, so whether it's a new section, but basically put a sunset on January 1st of 2027. That's a 2-year sunset. And then also require that, and I know Management Council doesn't like to be told this, but I think that this would be a topic of study for the Revenue Committee, for the 68th Legislature. Study in Title 39, Governmental Use, Taxation of Governmental Lands.
It's been moved and seconded. Any discussion? Representative Swan, sir.
Thanks, Mr. Chairman. Just a question, I guess, for the sponsor, if it really should be a revenue committee. I mean, this affects education, judiciary, it affects, if there was another court case that challenged any of the other similar provisions outside of our state land, we're in a world of hurt. So I guess my question is, I hate to ask for a select committee. Thoughts on that? I guess you put it in and during the legislature, you all decide where it should go, but it's a little broader than I worry it's a lot broader than an interim topic.
Mr. Chairman, I think that was, I don't disagree, Representative Swan, sir. That language that would be a friendly amendment to, a select committee created by Management Council, and it's probably a good point. I think then you get folks from a broad background in the legislature, and maybe it's several chairmen of several committees that study this, but it's going to take some work. So it's a pretty heavy-duty topic, so I would consider that a friendly amendment, I guess, is what I heard, was to make it more of a select committee. Is that what you're?
Mr. Chairman, even though I mentioned that, I think if you're going to ask for a select committee, then you got to define some things in here, and I don't want to take up your morning. I just wanted to plant that idea for the good chairman when it comes around to have some discussion on how broad this is.
Well, we have these, how about we have these 2 amendments really for a topic for revenue and the sunset date. Those are pretty clean amendments right now. I think if we can vote on those, and we can further amend maybe.
Yeah. Any further discussion on the amendment? Senator Hyde.
Thank you, Mr. Chairman. Yeah, just to be clear on the amendment, the purpose of the sunset is to put the brakes on what's going on right now so the county assessors don't have to try to tax everything. If we get this in by, retroactive January 1st, and then we work the bill further so we don't have to deal with that mess at the moment. Is that correct? Thank you.
Yeah, Mr. Co-Chair, is that correct?
Yeah, Mr. Chairman, I think that's a fair way to say that, I think, and it gives us some time, because this has a lot of implications. When this first came out in October, the co-chair and I, staff, we thought we better put this as the #1 topic, but really we haven't had enough time, barely a month, to kind of, this has been a kind of one of those topics that's been around for a while, and different legislators have been used. That's why you see the municipal statutes are way different than the state and county, because there's all these different things going on out there. And I think it's going to take a group, probably a couple of years, to look it all over and see, because this it's always changing, I guess, and it's going to take a good look. So I think the short answer is yes. But give us some time to kind of study this, figure it out.
Any more questions on the amendment? Ready for the question? Okay, all those in favor say aye. Aye. All those opposed? That amendment has been adopted. Back on the bill. Any further amendments on the bill, Mr. Co-Chairman?
Mr. Chairman, I think just kind of the discussion, I think the amendment was to have this a revenue committee topic, but I know the legislature is not, but some of I know we're not real fond of select committees and special task forces, but some of this really important work requires that, because then you get input from various committees. Management Council, the Speaker, and the President can pick members from various committees. bring in a broader kind of look, because sometimes us, folks in revenue, we just get kind of into this side of it. And so the amendment, Mr. Chairman, would be just to amend that revenue committee piece out to more of a special task force, appointed by, and we have classic language for that, appointed by the speaker and the president to study this issue. Make it more of a select committee.
Okay. Or second? Seconded by Pappas. Discussion? Representative Bear.
Just a little bit of clarification, Mr. Chairman, from your co-chair, the bringer. I mean, these are things that would be approved by the management council. So we as a committee, we're putting language into a bill here to encourage them, I assume, to go this particular route. Is this the proper method to do that, or is there another method? What have we done in the past as a legislature? Or just call upon your experience to clarify that for us.
Co-chair?
Mr. Co-Chair, absolutely, we could, if this goes into law, this would be a lawful task force that management council then would fund, and that, I'm deferring to our staff to write it, but the speaker and the president would appoint the members, and then they would report back. But it's not management council also can create special task forces, but so can individual legislation as well. So this would be individual legislation from this committee that would create that.
Follow up, are you good? Question for you, do we have to specify the number of members in this, or would we just leave it open to the speaker and the president?
Mr. Chairman, that was going to be my question as well, if you wanted to specify a number of members. I think we've done, 6-member task force is a fair amount, but whatever you want to do, I think we would need to likely have that. And if you wanted to say 2 members from revenue, 2 members from, you could do that as well. We've done it that way in the past, Mr. Chairman.
I think so too. And Mr. Chairman, I think if we want to get that detail, that's fine. And I was just thinking more of a, like a 10-member, 4 from the Senate, 4 from the House, appointed by the speaker and the president, 2 appointed by the governor. And so 10 members, equal representation from both bodies.
Is that good with a second?
It's good with me.
All right.
An odd number.
Some committees have odd numbers. I think many of these task forces will have even numbers.
Because there's no legislation coming out.
So there's,
Okay.
Okay, good. Any discussion on this amendment? Any discussion? Question being called, all those in favor say aye. Aye. All those opposed? Okay, that amendment's been adopted. We're back on the bill. Any further discussion or amendments on the bill? Question being called, Eve, will you please call the roll?
This is a roll call vote for 25 LSO 0362, government-owned lands as amended. Senator French.
Aye.
Senator Ide.
Aye.
Senator McEwen.
Aye.
Senator Pappas.
Aye.
Representative Bear.
Aye.
Representative Byron.
Aye.
Representative Locke.
Aye.
Representative Northrup. Representative Oakley. Representative Storer.
Aye.
Representative Strzok.
Aye.
Representative Swanitzer. Co-Chairman Harshman.
aye.
Chairman Beitman.
Aye.
14 aye, Chairman.
Thanks, Eve. All right, this will probably be our only opportunity for a break between now and lunch, so let's take it. Let's do 10 minutes. We'll be back at 9:53. Thank you. We'll be recessed till 9:53. We're going to try to get this meeting called back to order here. I think we don't quite have a quorum yet, so if you could find a senator or a representative in the hall and kindly ask them to come back inside, that'd be great. Get these horses back in the corral here.
We got a quorum.
Now, we have a quorum now, so stay here, Bob.
Don't leave.
Okay, next up on the agenda is item number 3, property tax, residential property, and Director Henson's here to give us an update on the property tax relief efforts from the Department of Revenue. Director Henson, floor is yours.
Again, thank you, Mr. Chairman. Brenda Henson, Department of Revenue. And what a difference a year makes. Over the past year, many of the pieces of legislation that passed last year have been implemented. Some are still waiting to be implemented. But as you all step up to the challenge of creating a fair and equitable tax structure, sometimes it's important to know, are these bills having the intended impact? And what truly was the result? So we know that over the past, we just heard about October's decision from the Supreme Court. We just saw the voters of Wyoming pass Amendment A. We'll talk about that a little bit more. But as we're talking about all these tools that you, as policymakers, have in your toolbox, I think it's important to see where we're at in 2024. So with that, I took an opportunity to put some information together. So the first slide that we're going to talk about is who pays property tax in Wyoming. You'll see there at the top, for 2024, residential assessed value exceeded over $10 billion, almost 32% of our assessed value. Last year, in 2023 tax year, that percentage was 28.895. Now, why did it increase? It's simply because the mineral value went down. You'll see on this slide, total mineral value is $14.775 billion plus, or 46.46% of our total assessed value for the state. That number, that 14.7 billion, is down from last year. Last year, we were over $17 billion in assessed value for minerals. It accounted for 50.75% of our assessed value. We lost $2.5 billion in assessed value in mineral taxation from 2023 to 2024. Now, keep in mind, mineral production is prior year produced mineral for 2024. So that's the taxes, the production of minerals in 2023. The next slide, we talk about how each county is unique. And we have some counties that are very reliant on minerals and some counties that are very reliant on residential. So the slide before you gives you each county and what percentage of their total assessed value is related to residential. That is our main topic of discussion this morning. Now, what you'll also see is that just because the county has a reliance on the mineral value, it may not be the same for that county seat. Municipalities are not impacted by mineral value like the counties are. For example, if you look at Campbell County, for example, 7.27% of their assessed value, Campbell County's government, is based on residential. But for the city of Gillette, 64.04% of their assessed value is residential. And these are important as we start looking at the impacts of these residential exemption bills that were implemented. And then as you go down, and if anyone's interested, we do have the calculated percent for every municipality in the state of Wyoming. If you're interested in that, we can certainly reach out to me and we'll share that. The next slide, I mentioned, what a difference a year makes. So the historical percent difference for residential assessed value per county going back 10 years. So, and this is not looking at one particular property owner's tax bill and what that increase is. This is looking at total assessed value for each county for each year. So all the new construction that occurs from year to year, all of the new subdivisions, All of that's included in this. So if you look at this and you go up through 2020, you'll see, yeah, there were some years that there were some double-digit increases in assessed value. But in 2020, you know, we only saw one county, well, two counties, I guess, that had 6% or more in an increase from assessed value from prior year to, so 2019 to 2020. Then you look at tax years 21, 22, and 23. Now, keep in mind, for residential property, county assessors are using prior year sales. So for 2021, you're looking at sales that occurred in 2020, and then following through. So we saw in 2021, we had 4 counties that had double-digit increases in assessed value percentage-wise, but 22 and 23 are where we really saw those big increases and where we had taxpayers across the state reaching out to you, their legislators, to say, wait a minute, what's going on? So again, in 2022, all but 3 had double-digit increases in assessed value. 2023, all but 1 had double-digit increases. Now let's look at 2024. Quite a different story. Quite a different story. Now, keep in mind, these percentages have that 4% cap on the residential structures, but I'm also going to provide you some additional information on that. But again, 2024, we even had a couple of counties where the total assessed value went down for residential in 2024. Now let's take a look at the minerals real quick. The next slide. The percent of mineral value to total assessed value. So if you look at those top 4 counties, Sublette, Converse, Campbell, Sweetwater, 81% of our mineral assessed value is right there in those 4 counties. The rest of mineral assessed value is spread over the rest of the state. And you can see where just because mineral values have increased or decreased, that does not impact all of those entities the same. The next slide talks about historical assessed values. So the red line is the all other classes, meaning all other property tax values excluding minerals. The blue line are minerals. So when we look at the gradual increase, and then we got to that 2022, 2023, where we saw that steep increase that was not typical, but now we're back to what we've basically seen in those years prior on the all other property. Mineral valuation, again, you know, it's a blessing and a curse to have your taxable value be comprised of a significant amount of mineral assessed value, because you're always chasing that. Is it, you know, it's going to be here this year, it's going to be gone. We saw that big increase in mineral value, but we all look at that decrease. So when everyone kept talking about, oh my gosh, this big increase that we saw in mineral assessed value, well, it only was a big increase because we saw the big decrease. It wasn't a big increase to the historical numbers. So keeping that in mind. So let's go to House Bill 45. 2024 session, no application, no income, no age requirement, no backfill. So the exemption for 2024 taxes exempted anything that exceeded 4% above 2023 values for those residential structures. The only time that that cap was not placed on was if either the property was acquired the prior year or if it was new construction or they added on to that structure. Then that 4% cap was not applicable. Also, keep in mind, we're going to add on the associated residential land under those structures for 2025. So you've got the example there. We did, the Department of Revenue, we promulgated rules. We did emergency rules, Chapter 14 rules to implement the 4% cap for 2024. Then we came back around and we have promulgated Chapter 14 rules again to take into account both the long-term homeowners exemption and this improved residential land exemption that starts for 2025. So we have some numbers for you. That 2024, what did that exemption do? What did that cap do? So You'll see the overall, what we've got is we know exactly how much assessed value was exempted in each county. We use the average mill levy per county to give you an approximate tax dollars exempted. So you'll see that 300,724,060, that was the amount of assessed value that was exempted. When we use the average mill levy, almost $19 million in taxes exempted in 2024. Taxpayers didn't have to do anything. Assessors, on a very short turnaround, changed their assessment schedules, got those out in a timely manner. But I want to give you some more numbers. So that 300,724,060, that 4% cap applied on 94,595 homes out of 233,576 residential structures that are on the tax roll. So about 40% of our homeowners realize some reduction in their tax burden based on this 4% cap. But the other point of that is 138,910 homeowners didn't realize any benefit from the cap because their property didn't appreciate more than 5% from 2023. So when we look at the tax amount and that 19 million, obviously the lion's share of that is education. So that 300 million in assessed value, when we apply the 12 mills for the school foundation, that was about 3.6 million that did not go to the school foundation. About 7.5 million that would have been the 25 mills going to the school districts. About 1.8 million that would have gone to the 6 mill school, county school fund. So about $13 million in education funds that were lost because this particular exemption does not have a backfill. That's for 2024. Now, keep in mind, this particular piece of legislation does not have a sunset. So this 4% cap that was applied to the residential improved, that structure for 2024 continues on. Now we add in the 4% cap on residential land. And my hypothesis is we're going to see a lot more exemptions on the land because it is very easy to see that $60,000 residential lot go to $65,000 in 1 year. Well, that exceeds 4%. So you're going to see some a significant number on those. The next slide that I wanted to show you, though, is, okay, what would it have been if it hadn't been there in place? So the next slide, you've got each county, you've got the 2024 total residential land with the 4% cap applied. And then the difference in total residential value between 2023 and 2024. And you'll see we're all single digits. In fact, we had 2 counties that went down, a negative. Now, what I've done is I've added in the exemption amount in that middle column that's highlighted. So without the cap, what those assessed values would have been per county and what the percent of increase in total residential value would have been had the cap not been applied. So we only had 2 counties that would have been in double digits, that being Crook and Fremont. Every other county only saw single-digit increases. And keep in mind, this is including new construction, new subdivisions. So again, just such a different world in 2024 based on market value. Again, we have 2 counties, Niobrara and Johnson County, that their assessed values were negative from what they were in 2023. Before we move on to the long-term homeowners, are there any questions related to the cap? I know we have a piece of legislation that would change how we administer that cap, and we can talk about that then, but any questions on how this was implemented for 2024?
Mr. Co-Chairman has a question for you.
Thank you, Ms. Co-Chair. Director, just, curious, do you have any numbers on how much of this is new construction?
Mr. Chairman, Co-Chairman Harshman, I don't have those numbers. We do know that there were over 4,700 new structures added to the tax roll in 2024 from 2023. But I don't have those numbers. I do have some information that'll follow with the refund program that talks about the median residential property tax bill that might be beneficial, but I don't
Well,
have
it's just
those.
kind of hard when it's hard to compare apples to apples, because you're not. You're comparing apples to apple with 4,000 more, structures.
So to your point, Co-Chairman Harshman, is that
Should be like
those
an
numbers,
average value or something. I don't know.
well, those numbers are then conservative because they do include all that new construction. So the actual percent of increase, if everything were remained the same, then it would be lower than the numbers that you're
Yeah,
seeing
that's what I
here.
mean. That's what I'm trying to figure out if there's a way to get a real accurate. Because what we're dealing with is trying to know exactly how much did, Mrs. Smith's property tax go up. Well, you can't really, because this is another Mr. Smith that moved in down the road, built a new house.
And Mr. Chairman, county assessors across the state, they value everything as we've discussed this morning on January 1, whatever the assessment date is. They've got field appraisers out in the field every day. We're using oblique imagery to identify structures, additions, and they're just listing it to make sure they have it right on January 1. In no sense of the word do county assessors on every parcel dissect what part of this value is historical characteristics and what part of this value are new characteristics. That would be a significant undertaking. But I understand your questioning the importance of that.
Representative Locke has a question for you.
Thank you, Mr. Chairman, and thank you, Director. Real quickly, just do you have a good feel on the average what the land adds? Is it, I've heard different numbers. I've heard it's on the average it's 20%. I've heard on the average it's 30%. Do you have just a rough order of magnitude? Where is it? Is it 20? Is it 25? Is it 30-ish? Thank you.
Mr. Chairman, Representative Locke, so that 20%, it's somewhat of a very fuzzy rule of thumb that when you buy a improved residential property, that the land is going to contribute about 20% of that overall value, meaning if it was $100,000, $20,000 would be attributed to the land. That is not across the board because we do get vacant land sales. And so we are able to value that land separately. Our Constitution does require that county assessors on the assessment schedule have a value for the land and a value for the improvements. And so it does not always follow that 20%. And in our more scenic areas, it definitely does not follow that rule of thumb because you definitely have some of the scenic areas in our state where the land is what the purchaser is really interested in, and the structure really is inconsequential. They don't even anticipate keeping that structure, but they're looking at that land value. So fair market value, what's the most important piece of valuing fair market value? Location, location, location. With that, perhaps it would be important that I turn your attention to that 4% page. One step back, Eve, right there. So when we look at that $300 million in assessed value that was the 4% cap, I turn your attention to Teton County. Half, $149,994,000, almost $150 million of that $300 million was related to that 4% cap being applied in Teton County. Anytime you have those areas where that real estate investment is appreciating at a higher rate, a 4% cap is going to be more beneficial to those property owners than to those areas where the market is fairly stable or flat. So I do think that's an important point, and I do appreciate your bringing that up.
All right. Any more questions before we move on to? Okay.
Okay,
proceed.
Mr. Chairman, we'll move on to the long-term homeowners exemption. A lot of buzz about this, and I want to say first and foremost, thank you to the county treasurers across the state who worked cooperatively to put language together, and every tax bill that went out in September had information for Wyoming property owners about the long-term homeowners exemption. We were charged with promulgating rules and creating the form. We provided those forms to county assessors across the state in September. They began providing that application to their taxpayers, and they have already started taking applications. And I wanted to give you a little bit of information on where we're at on that. So as of last Friday, approximately 14,500 property owners have applied. Now, we don't know if they qualify yet because county assessors across the state, they haven't valued their properties yet, right? We need to get through 2024 before they start actually appraising residential properties and determining those final values. And they haven't started processing those applications to see if they actually qualify. So we've got approximately 14,500 applications right now, with an average assessed value of about $17,000 in assessed value, which would equate to about $170,000 in fair market value that would be exempted. If we just took the applications that we've got to date, it's somewhere between $16.5 and $17 million in taxes, if all of those applicants qualify. Taxpayers have until the fourth Monday in May to apply, which, as you know, assessment schedules have to be out in April. We know that that's going to remind everybody that they don't need to reach out to their county assessor if they believe that they are 65 years of age or and have paid residential property tax for 25 years or more. So we anticipate there will be more, but based on the efforts of county assessors, county commissioners, county treasurers, getting the word out, I think that we've really got a good starting point to know how many applications we'll have. I did go ahead and include the application itself. It's a 2-page form asking the property owners to basically provide proof that they are 65 years of age. And there was a provision in this law that said that the first year, somebody has to qualify. And then there's a provision in there, and we'll have another bill that we're going to talk about later this morning, that had a provision that if you're a surviving spouse of someone who qualified previously, that you could continue to receive that exemption. That won't come into play for 2025 because somebody has to qualify first before that piece would come into play, and we'll discuss that later. But you can take a look at our rules. Again, 50% exemption of assessed value for the residential structure and up to 35 acres of associated residential land when the land is owned by the owner of the dwelling. We did require within our rules, if it's a mobile home, that if you own the land underneath that mobile home, that you need to apply on, and it's assessed separately, you'll need to apply for each one of those. And so I believe that clarification. Now, we do know that there's a sunset on this bill of July 1, 2027. My interpretation of the discussion was that they used July 1, 2027, thinking that it would be a 2-year bill, 2025 and 2026. Tax bills don't go out until September of 2027, and so it would have already sunset. It might be helpful to clarify that that is January 1, 2027. We talked about this morning how everything is assessed and taxed as the laws exist on January 1, so it might be helpful if that is the intent. Again, there is no funding for this exemption. All taxing authorities will be impacted, but mostly, again, municipalities, those taxing entities that are more reliant on residential will be impacted more. Those communities that have a larger senior population will be impacted more. Those improvement districts where the property owners within that subdivision gathered together, created an improvement district to pave their lands and pay back a bond. You know, if there are a lot of senior citizens within that improvement district, they may be impacted. Now, what's interesting about that, and I would be remiss if I did not mention this, if I'm an improvement district and I borrowed money, the way we calculate mill levies is budget divided by assessed value equals a mill levy. So if you exempt a significant amount of assessed value for anybody who has a bond that they're repaying, now what you've done is increase the mill levy on those taxable assessed dollars. Okay? That's only with a principal and interest payment. If you have someone like the education program where everything's at, you have to, you have to value the 12 million, you have to value the 25. Those are the entities that are just simply going to take a hit because they're not going to receive taxable value on those. But if you've got a bond to pay back, the mill levy has to increase to pay that. Any questions on the long-term homeowners?
Senator Ide has a question for you.
Thank you, Mr. Chairman, Director. Part of the litmus test is you've got to be in that residence 8 months out of the year. I assume that's just on the honor system. What happens if somebody, it seems like it would force people to be maybe less than honest, say they were there 7 months and 15 days. Do you police that? Don't you think this bill would be better just to take that part of the litmus test out of this bill? Thank you, Mr. Chairman.
Director?
Mr. Chairman, Senator Ide, that was a policy decision. The legislation that was passed required that 8-month. It should also be noted that most of our other exemptions that require primary residence, whether it's property tax refund program, veterans exemption, they all require that there's at least the majority of the calendar year, whether it be 6 months out of the year that they have to reside in that property to get that benefit. But that's certainly under the purview of this committee if you wish to change that. It is on the honor system. You'll see the application right before you. Taxation in Wyoming, everything's based on an honor system. There is a penalty. You'll notice that on the last page, it states that I certify under penalty of false swearing that the following is true. I'm 65 years of age. I use this address that I'm applying for as my primary residence for not less than 8 months of the year. The reference property, I own this property. So whether it's personal property reporting, the property tax refund program, this tax relief, the veterans exemption, we rely on the citizens of the state to be honest. And I believe that they are in most cases. And those that aren't, it doesn't matter what you put in statute, they won't be honest.
Representative Locke and then Senator French.
Thank you, Mr. Chairman. Thank you, Director. And a couple of real quick questions. Do you kind of have an estimated number of people who could qualify over the 65? Let me just put it in that category. And I don't know if you can chip that down to how many you can estimate have been there a long time. And the second question is, and you probably said this, I didn't catch the number of applications you're expecting. So thank you.
Director?
Mr. Chairman, Representative Locke, this has been a real challenge. When this bill first came to us at the Department of Revenue for a fiscal note, and we started looking at demographics of the state of Wyoming and how many people do we have in the state that are 65 years of age? We had some numbers there that we could get. Now, did we know how many of them owned their homes? Yeah, we could kind of get a number there. But what we didn't know is how many had paid property tax for 25 years. Our estimate early on was about 6,500. We missed that. Our estimate was 6,500. Economic analysis, they had an estimate of over 100,000 that they believe may qualify residents. I think you've got another document that Taylor DuPont with LSO has provided that estimates that at about 28,000. So that estimate, depending on what you base it on, is very broad. And the best number I have right now is we're at 14,500 today, the applications that have been provided to county assessors across the state. But we still have until the fourth Monday in May 2025 for those applications to come in. And just as a rough estimate, when we take those 14.5 thousand, and we look at what their appraised values were last year, approximately $17,000 in assessed value is what we're estimating as an average, as a exemption. And I mean average, not a median. I'm just saying, when you take total applications divided by what that assessed value is, divide it in half, about $17,000 in assessed value, which would be about $170,000 in market value, is what that exemption means to those senior citizens for 2025. We'll have better numbers after tax roll in September of 2025. That'll be the first time that I will be able to provide to this committee what did that long-term homeowners exemption cost to all the taxing entities within the state of Wyoming.
All right. Senator French?
Thank you, Mr. Chairman. Just to add to what Senator Ide said, you know, I had neighbors come to me within the last month and asked me to change, I know we're going to get to it later today, change that 8-month thing to 6 months or do away with it, because they've bought a fifth wheel trailer in Powell or Cody, and they go to Phoenix and rent a spot in an RV park. They leave in October and come back 1st of April. So they don't want to lie. I mean, they're upstanding folks, work their rear end off for a long time. They still pay on that house that they've been in for 50 years. You know, it's the moral thing. They're like, God, we can't lie about this. So we can't qualify, or we cut our time down south. We cut that down so we can honestly say we've been there for 8 months and a day or whatever. So just to comment on that, I mean, my parents did that for 30-some years, pull their little Airstream down to Arizona to an RV park. And, you know, they, under this scenario, that 8-month thing, it would be, they wouldn't even apply because they wouldn't want to lie about it. So I know we'll address that later. So just a comment.
Mr. Chairman, Senator French, I would take us back to a couple of years ago when this was an interim topic, residential property tax relief. And one of my first statements was, to whom do you wish to provide property tax relief? And that, I believe, gets to your point. To whom do you wish to provide property tax relief? The way the legislature structured this particular tax relief was for those homeowners that reside in Wyoming 8 months out of the year. I believe the discussion at the time was, were you really wanting to provide significant 50% of their residential property tax bill, significant tax relief to those citizens that weren't here for a significant portion of the year? Keeping in mind that what our property tax is, it's how we pay for services. So this is definitely a policy decision for this body.
Follow up?
Thank you, Mr. Chairman. Right, but come on, they pay taxes on that house, whether they're in Arizona or in Powell, Wyoming. They're paying taxes on that for a full year, just because they're gone for a little bit. So I hope the committee will amend that when it comes around. Thank you.
And Mr. Chairman, I'm not advocating either way. I'm just stating that we put rules in place and are administering this policy as stated in law.
All right, moving on.
With that, I'd like to turn to the 2023 property tax refund program. This was expanded during the last session. You've got another bill that is just basically a cleanup bill. The legislature wanted to create two additional tiers, one at 145% and one at 165%. The governor did veto and eliminate the tax refund that was available from 145% median household income up through 165. 165 is still in statute, but there's no refund available. But let's just look at who did we send checks out to? So the Department of Revenue, we received 14,782 applications. Within the PowerPoint presentation, I've got focus on what the relief was for 2023, but I also did bring this document that shows the detailed information comparing 2022 refunds to 2023 refunds. So the 14,782 in comparison to the 9,719 we received in the 2022 tax year. 13,485 refunds totaling $14,269,323. Now, interestingly enough, of those that were rejected and we didn't fund, it was about 9%, which is, we had 9% in 2022 that didn't qualify, and about 9%, even with the increased numbers, about 9% that didn't qualify in 2023 for the refunds. Now, the main reason for that is income. There's always a confusion. Our statute for this exemption is median gross income. Many times, property owners apply for this benefit because they are looking at their net taxable income for income tax purposes. That's not what this benefit is based on. So when we look at the exemptions that were granted, $14.2 million, you may recall that the governor's original ask for the budget was $20 million for the biennium. And prior to the expansion of up to 145%. We didn't receive any additional money. We didn't get any additional money for those additional expanded program. So we've already spent $14.2 million. So our agency asked for $10.5 million in the supplemental that you'll be considering so that we can have enough money to fund the program for 2024 refunds. So again, this is a refund program. Taxes have to be paid by the applicant before they can qualify for the refund. So in that April, May, June time period, we'll be taking applications in 2025 for 2024 refunds. These numbers that you see before you are for the 2023 tax year and the refunds. Again, when you look at the numbers, we've got 5.7 left. We'll add the 10.5 million. We believe that that will suffice. One thing I found interesting, if you look at these, we went ahead and broke it out so you could see how many received the refund at 100%. That's that second column on the PowerPoint presentation. So the refund at 100%, that means those are the applications that their median household income was less than 125% of the median household income for their county or the statewide average. So the number that were approved, 12,406. When we expanded to the 145%, that's that dollars refunded at 65%. Because between 125 and 145, that refund amount is only 65% of what you would have received if your income was less than 125% of median. We only saw an increase of tax dollars refunded of $790,000. We only added 1,000 applications, 1,000 more refunds. I believe the reason for that we didn't see a significant number there is because the more your income increases, typically, so do your assets. So more people did not qualify because they exceeded that $157,000 per adult member The number was 156,900 per adult member of the household. Once you get into those higher income numbers, they have stuff, and they don't qualify for this exemption. So that is not where it expanded. When we go to the next slide, when we talk about 2024 and where we're going to estimate that 2024 median residential tax per county. So we already know what those numbers are for 2024 because 2024 tax bills went out in September. So if you look at this slide, that percent change on the median residential property tax bill is in that far right column. 2.44%, 2.76%. Again, single digit increases in that residential. Now this does reflect the 4% cap. But when we're looking at those, we only have one county. Sublette County is the only county where that median residential tax bill went up over 6%. And we had 4 counties where for 2024 property taxes, the median residential tax bill was actually less than it was in 2023. So we believe that our numbers for the 2024 year are going to be about what we had for this year. Now, this is the residential property tax bill. We won't know residential median incomes till after the first of the year. So when we get into the legislative session, based on the information from economic analysis, I'll be able to provide you with that. But the reason we saw a significant increase was because those income numbers increased. 125% of median household income from 22 to 23, there were significant increases. And if you may recall, I gave you that information last year. That's why this program expanded so much, is because more people qualified. Along with that, we had the 2023 county optional. Now, you may recall that bill also expanded that to the 145%. Now, we didn't have any additional counties that funded that refund program, so we had the 5 counties, the same 5 counties that provided funding. And remember, this program, the optional, is totally funded by county government. They are the ones that fund that. And the deadline for that application was October 14th. And county treasurers have until the end of December 2024 to issue all of those refunds. And those are tracked at the county level, so county treasurers could provide you with the information. But the key about this county optional program and the refund program is those are both backfilled. So it is no hit to the taxing entities that provide the services. Any questions on the property tax refund program?
Representative Wanitzer.
Thanks, Mr. Chairman. So Ms. Henson, last year we said 20 million. We were under expectations, or I guess we were over expectations on utilization. And I feel you testified and you said, hey, if we get to 20 million, the executive branch, we're going to cover all these. And here we are a year back saying, well, now you need another 10. And that's just because the legislature opted to expand the classifications and give more tax relief, or are there other things going on?
Mr. Chairman and Representative Wanitzer, the 20 million was before we had median household income numbers. So that was a surprise, I think, to everyone that the program expanded just simply that 125% of median household income. That number increased. And then the additional, 700, 800,000 for the expansion to the 145%. But you're absolutely right. We had more taxpayers take advantage of this program than we've ever had before. And I did not envision that.
Follow up?
And still correct, Mr. Chairman, that if they qualify for the over 65, they can't qualify for both? Or the veteran, they still have to choose one of these programs besides the cap, and then they could still do the relief, is that correct? And is that figured into your numbers, all the people doing the over 65 cap?
Chairman Beitman, Representative Swanitzer, there are no statutory provisions limiting the number of exemptions that taxpayers can take advantage of. None. I can automatically, if my property appreciates, my residential structure appreciates more than 4%, I automatically receive that cap. If the residential land increases over 4% from the prior year, I automatically receive that exemption. If I qualify for the long-term homeowners exemption, I receive that exemption on top of that. If I'm a veteran, and we're going to we're going to cover that program doubled starting in 2025. If I am a veteran and I qualify for that program, I can receive that exemption. If at the end of the day, whatever I paid in residential property tax, if the program is funded, the property tax refund program is funded for 2025 refunds, I can qualify for that. There are no provisions currently in law that limits my ability to take advantage of property tax exemptions on residential property.
Okay. Any questions before we move on to veterans?
Okay, real quickly, Mr. Chairman, we'll cover the Senate File 89, the Wyoming Veterans Property Tax Exemption. Everything else within this program stayed the same. All of the qualifications are the same. This particular program is funded by the State General Fund with an appropriation. The assessed value for that for 2024 was $3,000, a maximum of $3,000 assessed dollars, which depending on what the mill levy is for your tax district, somewhere around $205, $210 of an exemption. For 2025, that exemption is up to $6,000. And there was an appropriation, that money is in the the state treasurer's budget. What happens is this exemption is granted. County assessors provide the Department of Revenue with all of the tax relief that was granted by September 1st of each tax year. We then provide that information to the state treasurer's office, and the state treasurer's office sends dollars and cents right to the penny. Any veterans exemption that was granted, the state treasurer's office sends that backfill to county treasurers who distribute that money just as if the property owner paid that. So that will increase. And I did go ahead, provide you with a summary of the veterans exemption for 2024. So when we go down, so on the first column, you'll see real and personal property. That's your site-built structures and also your mobile homes are included in that real and personal property. So the veterans exemption, you can use it on your primary residential structure, which is defined in statute as to how long you have to be in that structure. And you have to have a 3-year residency to claim that exemption. And you have to have received an Armed Forces Expeditionary Medal or equivalent to qualify for that benefit. So not all veterans receive that exemption. But you'll see that 19,379 veterans did receive that exemption in 2024 on their residential structures or mobile homes. Under motor vehicle and trailer, we don't have it broken out, but some of our veterans don't own their primary residence, and so they use that assessed value on their vehicle. And those numbers are included in this motor vehicle, but these numbers also include the prisoner of war benefit that the legislature grants, the disabled, and the Indian license fee exemptions. So those are included in there. But overall, total exemptions were 32,000 veterans that received some sort of an exemption. In comparison to 2023, we saw 19,127 veterans receive the exemption on their primary residence, so we're up about 252. The amount of the tax credit, we're up over $4 million that the state of Wyoming has paid on behalf of those veterans for 2024. That was a little over 39 or 3.9 million. We're up about $61,000 on the primary residence from the prior year. But definitely those numbers are going to double because of the exemption being expanded to 6,000 versus the 3,000. Any questions related to the veterans exemption?
Senator Pappas has a question.
Thank you, Director. I think you've told us
this before, but just bring it to our attention again. How is this exemption taken in light of exemption House Bill 3? They're both available, correct? If you are eligible for both of them. And I just don't know how it's calculated if they're both valid. Director?
Mr. Chairman, Senator Pappas, you find yourself in the challenge that all of us that administer property tax find ourselves in. What's the sequence of all these exemptions? Right now, the sequence that we've got is we'll be applying the 4% cap on the residential structure, then the 4% cap on the residential land, then the long-term homeowners exemption would be 50%, and then whatever is left, then we'll apply the veterans exemption to, and then see what the remainder is in the taxable value. But when you have all of these moving parts going on, when it's confusing for those of us that administer this and eat, breathe, and sleep it, I'm sure you can imagine how confusing this is starting to get for those taxpayers that are trying to figure out what their benefit is and what their tax amount is. On your 2025 property assessment, you did ask that county assessors include down at the bottom of the assessment schedule, we're putting on there. This is what your tax would have been without any exemption. This is what you're estimated based on prior year mill levy. This is the benefit of the 4% cap, if it was applicable to you. Here's the benefit of the land, if it is applicable. Here's the benefit of the long-term homeowners, but only if they apply before the assessment schedules go out, because if they haven't applied yet, it's not going to be on the assessment schedules. It'll be reflected on the tax bill in September. If you get a veterans exemption, if they've notified the assessor prior to the assessment schedules going out, that'll be reflected on the assessment schedule. But in some instances, the assessment schedule, we don't have all the information to let the taxpayer know what exemptions that they've received because they may not have even applied for them yet. So therein lies the challenge that those of us that administer the tax have in educating the public as to what they're entitled to under the current law. Then we're going to get into Amendment A and how that impacts, because we are a fractional assessment state. And when you apply a level of assessment, bottom line, as a legislative body, you're saying we value based on fair market value times the level of assessment. If that level of assessment is 11.5%, everything above that 11.5% is exempt. If that level of assessment is 9.5%, we're not taxing you on the remainder of your fair market value. We're only taxing you on 9.5%. So level of assessment, that valuation piece, is a form of an exemption to the taxpayer. So that'll be another piece that we'll talk about at that time. So great question. Thank you for that.
Representative Baer.
Thank you, Mr. Chairman. Director, for the sake of the audience, could you just describe the sunset for this veterans, not the whole exemption, but this new additional $3,000 exemption?
Director.
Mr. Chairman, Representative Baer, there is no exemption, no sunset for that exemption. It was $3,000 assessed dollars, now it's $6,000 assessed dollars, and that will be in place until the legislature changes statute. Thank you.
Okay, good job. That was
Thank you, Mr.
A lot of
Chairman.
information.
It's been a busy year.
Yeah, I bet. We appreciate you and thank you for all your hard work and your department's hard work on.
Absolutely, I do
implementing
want
this
to give a
policy.
shout out to all of those folks that have a part to play, whether it's my staff at the Department of Revenue. Ken Gill and his crew have been phenomenal in trying to implement all of these changes. Our camera provider in trying to get the programming done. You may recall we're right at the beginning of also, in addition to implementing bills, we're right in the middle of converting from an Oracle database to a SQL database and moving to the cloud. So they've got that on their shoulders. Thank you to local government. Thank you to those county treasurers and county assessors that, for the good of their constituents, they did everything they could to implement the tax relief that this body put in place last year. Thank you.
Thank you very much. And are you going to testify individually on these bills as we go through them, or do you have just general comments about any snafus that we need to fix on these bills? You're going to take them one at a time or do them now?
Mr. Chairman, my intent is I'd like to make a few comments related to the Amendment A when we get to that and the administration of that and the steps that need to go in. But for the rest of the bills, I don't intend to testify unless there are specific questions. I'd be happy to answer those questions. Now, when we get through this afternoon, we talk about the appraisal and valuation of personal property. We'll have some clarifications for some of the documentation that we've provided related to fiscal cost on some of those changes. But I don't anticipate testifying on each individual bill unless you deem it appropriate.
Okay, we'll call you up if we need to phone a friend. Thanks, Director. All right, so now, next item on the agenda is the Constitutional Amendment A, separate residential property class for tax assessment. Josh Anderson, our senior staff attorney, will walk us through Amendment A and the implications of that. Welcome back, Mr. Anderson.
Good morning, Mr. Chairman.
Mr. Chairman,
Senator Ide?
do we have the paperwork on what we're going to discuss here right now? Thank you.
It should be in your packet if we have anything.
Mr. Chairman, we didn't have anything. Certainly you can look at Senate Joint Resolution 3 from 2023. That's what passed. We can certainly get copies of that if we need to. I'll just run through that really quick. As you know, this passed the voters at this last election. And what the Amendment A did, or Senate Joint Resolution 3, currently there's 3 classes of property: gross minerals and mine products, property for industrial purposes, and then all other property, which included commercial, personal, agricultural, as well as residential. And all this did was change that from 3 to 4 classes, and then separate residential real property from those other types of property: commercial, personal, agricultural. You can see what it does tie that rate to the rate set for industrial property, so it cannot be more than 40% or 4 percentage points less than the rate for industrial property. And then it also authorized the legislature to create a subclass within that class of residential property for owner-occupied primary residences. So that is essentially what the amendment did. It didn't do anything by itself. It necessitates some action by the legislature. I think at minimum, I think there's 2 places in law where those 3 assessment rates are. It's currently 100% for mineral property, 11.5% for industrial, and then 9.5% for all other. I think it would likely be recommended to go in there and add a 4th class of residential property and then specify the rate for that. Of course, if you didn't want to make any change to that, it would still be that 9.5%. And it may be beneficial to define what is or is not residential property. And that's essentially, I think, what the next steps are. I believe Director Henson has some additional suggestions that they might have for administering this.
Okay, Director?
Thank you, Mr. Chairman. Just as Josh indicated, as the legislature knows, that it provides you with some opportunity. But definitely based on the language that is now in the Constitution, and now the way that works is the governor and the canvassing board, they certified the election results last Wednesday. 10 days after the certification of that is when the Constitution changes. So the Constitution, although it's not in print, the Constitution changes this week to reflect that 4th class. Now, the legislature has the ability and the responsibility of determining what the level of assessment is we've talked about historically that the legislature, every year that you go in session, you have the ability to change those levels of assessment. Historically, they have not been changed since we went to fair market value as a basis for taxation. They've been that 11.5 and the 9.5. But for those of you that have been in the legislature, you do know that there have been bills historically to increase the level of assessment and decrease the level of assessment, just depending on what the assessed values were and what the cost of services were. So the first step for the legislature is to define what is residential real property. Okay. The other piece then is to determine whether the legislature wants to create that subclass for owner occupied. And if you deem it appropriate to have a subclass of owner occupied, then you're going to need to define what is the criteria for owner occupied. So those things all have to be identified. Now, administratively, what's the next step after statutes are put in place to define those things? The next step is your State Board of Equalization has the responsibility of determining the form of the abstract that is used by county assessors across the state and within the CAMA system. So for example, I can tell you today, single-family residence, improved land. I've got 180,658. I know exactly how many detailed lines across the state. Improved land, agricultural residence, 12,003. Single-family residential improvements, site built. Single-family residential improvements, manufactured home with a canceled title, meaning that property owner has asked that be valued as real property now. We know how many there are. How many manufactured homes do we have in this state that are titled? 30,140. The reason I have those numbers is because the state board's abstract identifies each abstract, and every line that's in the CAMA system has that abstract code assigned to it so that they can report. The reason I tell you that is whatever changes you make, as soon as the state board changes the abstract, we program the CAMA system to have those new abstract codes. Now the county assessors across the state have the burden of making sure that those properties have the right abstract code. So let's take, for example, should you decide to create a new class for owner occupied, and should you decide that that level of assessment is different for owner occupied than non-owner occupied, that's a significant change to that taxpayer, right? And the only way the county assessor is going to know that it's owner occupied is if the owner of the property tells the county assessor. Now, we have estimated that out of the 233,000 single-family residential properties in the state, about 170,000 of them, 170,000 are owner occupied, but we don't know which ones. Somehow, we would need to prop up a system by which property owners can notify the county assessor of where their primary residence is, and based on the criteria that you establish as to what is considered owner occupied. All of those parts have to be in place before the assessment schedule can go out to implement Amendment A. Now, that being said, as Josh indicated, is it possible that this body could simply determine that the level of assessment for residential for 2025 is the same level of assessment as all other property, so that ultimately there's no harm, no foul to those residential property owners for 2025, and it gives county assessors across the state, along with the State Board and the Department of Revenue, time to implement anything else that the legislature wishes. But if you wish to implement some of those changes for 2026, you would need to get those statutes in place during the 2025 legislative session so that we can go through all the rest of the process to get it implemented for 2026. if you anticipate making this an interim study in 2025, because this is a big deal. The Constitution changed, the implication of that and what your constituents want, and you're reaching out to your constituents to see, because I think there was a little bit of confusion on what exactly Amendment A did or didn't do, because it doesn't do anything until you all determine what it does. So I think that fact-finding for you folks, that's a heavy lift. And I think that everyone in this room that administers property tax wants to do it right. So is it possible that we just look at making the level assessment on residential real property the same as the all other property for 2025, perhaps 2026, that may be an option? But I just wanted to have an opportunity to let you know that it is not as easy as just saying residential property is at a different level than the all other property, because there's a lot more to it administratively for your county assessors. And I'd be happy to answer any questions.
Director, and maybe Josh, you can chime in on this too, just so the public is clear on this, because this was a point of confusion I kept trying to explain to people. So if we, now with this fourth class, does this fourth class still have to be within 40% or 4 percentage points of industrial, which is the highest? You're shaking your head.
Yes, Mr. Chairman, it does. It has to be within
So
that same range.
if we were to drop it down, we'd have to drop industrial down to a lower amount. What's the, at this point, at 11.5% for industrial, what's the lowest we could go to stay within the
I defer to maybe Dean. I think it's around
8.3 or something like that?
Mr. Chairman, Chairman Beitman, the exact percentage is around 8.21%. I could see the legislature perhaps rounding that up to 8.25%.
Okay, 8.25. Okay, so just so the committee knows and the public knows, the lowest we could go would be 8.25 to stay within the constitutional framework there.
Mr. Chairman, unless you reduce the level.
Unless we
of,
dropped everybody down. Yeah.
Industrial.
Okay. Committee, any questions while we have them up here? On Amendment A? Seeing none, thank you very much. Any committee directives or just keep on trucking? Keep on trucking. Next item up on our agenda is Bill Draft 25 LSO 166, property tax exemption for residential property revisions. Welcome back, Mr. Anderson.
Thank you, Mr. Chairman. Josh Anderson. So this is a bill that was requested at our last meeting up in Casper. There were essentially 3 different requests that kind of all got bundled into this same draft. And this is changes to House Bill 45 from last year that was discussed earlier that implemented that 4% cap on property taxation, so that any amount above that 4% is exempt. So the bill, as I noted, does 3 different things. The first, on page 2, Mr. Chairman, this would change that rate of exemption. Currently, as noted, that was 4%. This would change that to the rate of inflation or 3%, whichever is less. So that would provide us a lower cap on how much it could increase, and increase essentially the amount of the exemption. Over to page 3, Mr. Chairman, the second part of the request is to add to the definition of what is single-family residential in structure to include any outbuilding associated with that single-family dwelling unit, including attached garage, shed, or other associated structure, as long as that's not used for commercial, industrial, or agricultural purposes. And then at the bottom of page 3, Mr. Chairman, the third part of the request, this would essentially be a county option. And what this would do, it would give the County Board of Commissioners the option to administer the exemption as if it were in place in 2020, so that the 2019 tax year would be the base of determining the exemption. It would require the department to adopt rules providing for the administration of that exemption. There is a staff comment you'll see on page 4 related to that. It's just on the administration of how that would work. It would be important to address how some of those intervening changes that are in the exemption. So if it's sold or if there's additions to it, how you would address that from 2019 to when this would go into effect in 2026. So I think there are some questions there that are policy choices that the committee may need to think about. The rest of the bill, Mr. Chairman, then is those same changes essentially made to the other part of the exemption, which is the exemption to improved land. So that is essentially the bill, Mr. Chairman. And I would note on page 6 then that it would apply beginning in tax year 2026. And I take any questions.
Any questions? Representative Locke.
Thank you, Mr. Chairman, and thank you for going over this. So real quickly, are the rules that were originally put in place for how, when property would be reassessed, for example, are there enough rules in that original bill to cover these nuances? Can you describe what this adds additionally that would cause problem? For example, if you went back to, if you did the rollback to 2019 values and rolled forward, and you rolled forward on the guidance that was provided within 45, what's missing? If you could just give us some examples, that's what would be helpful to me. Thank you.
Sure, Mr. Chairman. I think it would just be important to provide a little more detail. If that is intended to be to just apply it as if it was in place, then, how would they be able to track back any sales? I mean, I think it raises those questions of how they could actually go back over those last 5 years and how many times has this sold? What would be the rate if it sold in 22? I mean, I think it just, and if that is the direction that it should just be applied as if it was, I think that's fine. We just would likely need to state that. And then I would actually defer to the department and to the county assessors, as they may be the ones that could answer those questions of how this would be difficult for them, or could be difficult, Mr. Chairman.
Thank you, Mr. Chairman. So if, for example, if we went back, whenever it sold would be the last date of assessment, for example. So you're saying that we may need clarification on things like that, just to make sure that's in there. But then in terms of property changes, I know in 45, one of the things that was put in there was the fact that if it was a major change, I can't remember the exact words, I'm sorry, but for example, if it was a major change, of course, there's a reassessment. So there's just a couple of points you say that would need a little bit of additional clarification, is that right?
And yeah, that's correct, Mr. Chairman. I think another question would be if it's a new construction, and similar things like that. Again, I think could be handled potentially, but it just would be something we need to specify, I think, in the law of how that's intended to work.
Okay. Senator Ide?
Thank you, Mr. Chairman. Thank you, Josh. On page 3, where, you talk about the county commissioners and it says they may instead of they shall, do they have any incentive to go back to 2020 with the way this is worded? It wouldn't seem that they would. Thank you, Mr. Chairman.
Mr. Chairman, yeah, I certainly wouldn't require them to do so. I think it would just be up to them and their constituents as to whether to do this. I think that was, and it's in that bill that way because that was the way I understood the request, was to make this an optional program. And I would note that, the county commissioners would be making this choice as drafted, but it would affect, other taxing organizations that may not get a say in how that's done. Just one thing I would note, Mr. Chairman.
Thank you, Josh. Any other questions for Mr. Anderson? Thank you. Appreciate it. Oh, yes. Representative Locke has one more for you.
Thank you, Mr. Chairman. I'm sorry about that.
No worries.
So if you simply change the may to shall, Is that sufficient to require it? Or is there additional wording that needs to be put in place here?
Mr. Anderson?
Mr. Chairman, certainly it could be a shallower. I think in that case, we likely wouldn't have it as a function of the county commissioners. We would just restructure the exemption in a different way to make it required to be administered as if it was in place back then. So I think it would be another, it'd be structured differently in the bill, but you could certainly do it and make it a mandatory change.
Okay. All right. Free to go now. We'll open up to public comment. Anybody wish to comment on Bill Draft 25 LSO 166? Ms. Huxtable.
Mr. Chairman, members of the committee, Dixie Huxtable, Converse County Assessor, and again, I'm going to speak today as the county assessor because we've not, as an association, taken a stand. And I just have a couple of things that I feel like need to be some clarification. And specifically, I'm starting on page 3 when we're talking about adding the additional buildings, because that does have some administrative concerns for me. When you've added a new building, this is where we come back to some of that structure. Let's take into account an agricultural account that has multiple buildings. That agricultural producer is presuming, and we tend to agree with them, that all of those buildings are agricultural purpose. Okay, they've got them on their land, they're using them for an agricultural purpose. Could be a storage shed, putting hay, could be putting whatever. Now think of the person that's not ag that has those exact same buildings, but they are storing maybe their private lawn tractor or their old cars or whatever. So the difference is one is possibly going to get it and possibly not. So what it says in here is that if it's a structure not used for commercial, industrial, agricultural, so those buildings outside of the residence are not subject to that, are not going to be eligible for that cap. The other, they are if they're just not on ag. I think there's some clarification that needs to be made there because we could have the exact same building sitting in 2 different places and one's going to be part of the cap and one is not. Now, I don't know that our system can actually cap one building separate from another building. So maybe they've got 3 sheds on there already. The homeowner in the subdivision has his garage, he's got 2 or 3 tool sheds and another shop. He's going to add a third one, or he's going to add another shop. That's a new structure. Is that not eligible for the exemption, or is it? My system has all of those under the same abstract code. You just heard from Director Hinson that those codes from the State Board of Equalization, all of those buildings have the same code in our system. I don't know that I can change this exemption for just one of those buildings with the code. I don't know how the system will do that. But there are some administration challenges with this. And the biggest one for me was the ag versus the non-ag person. Is one going to get it and one not? And then back for the rollback on that same page, I just want to make sure everybody understands, when property sells, it's really easy for us to identify what the value is when it sells, but we go out to property once every 6 years by rule. That's our requirement. We pick up things, maybe they finished the basement that wasn't finished before. They changed the inside. It went from a lot of deferred maintenance to being an average quality because they've taken care of it or they've updated it for sale. Those are things that happen every time we go out there. Can I go back to 2019 or 2020 and revalue that in that year, but I didn't pick it up for 21? The logistics of how we do that, I don't believe we have in the system right now. Certainly the department can probably clarify that to a certain degree. It's not just whether it was sold or whether it had a new addition on it. Those are easy. It's the rest of the characteristics that add to that value that we pick up that we can't go back in time and revalue them because they're all structured based on a cost table that's tied year to year. I think the rollback would be very difficult for stuff that's got new changes. And it doesn't have to be a new house, it doesn't have to be a new garage. It's just stuff that we've picked up. What is the direction you're gonna give us to go back to 2020? And that basement wasn't finished then. So I'm gonna use that value. When do I apply that change for that new basement, or vice versa? It did have a basement and now it doesn't. At what time in these rules and these procedures are you gonna give us guidance to manage that so we can manage it fairly and equitably across the table? I think that's our concern, just making sure that there's clarity in this so we know what we're doing. And I would stand for any questions.
Representative Locke.
Thank you, Mr. Chairman. Thank you. Question on the first one. How would you propose, or what's your view of something as simple as, because really the intent of this, and I will take the blame for it, but really the intent of this is person has a detached garage, it should be included. It's common sense from my perspective. So we're not trying to make it complicated, but how would you make it simpler? And then the second question on the rollback, I think conceptually, at least, and the intent of the rollback was that property assessed in 2019? Hence, is that not the value? I mean, what's new? We're going to go back and reassess in 2019? I don't think that was the intent. I think the intent was what was it assessed for in 2019. So I don't think we're looking to go back and say, hey, we're going to go magically go back, reassess everything in 2019. I don't believe that was the intent, but I'd like to hear your thoughts on those two things.
Ms. Huxtable?
Mr. Chairman, Representative Locke, I don't have a good answer for the language. The detached garage was already in some of this language. So it says that it includes any outbuilding associated. You've added detached garage. Maybe just detached garage is the only thing that you add. And you leave the other sheds and buildings out of this new language. Detached, if that's what your focus is, leave it at detached garage. If we have, shed leaves it open to a lot of other definitions. And it says other associated structures. And I just had the concern when I sit here and look through my ag accounts and my non-ag accounts, and I'm doing that right now for my job, and what the inconsistency in that could be. If you just want detached garage, label it detached garage. When you start adding other associated thing, that can be a lot of different things. People have a lot of different definitions for their associated things. In regards to the rollback, I just need some clarity of what I'm going back to this property. I'm looking at the 2019 value. That was valued as it was on January 1st of that year. In 21, I picked up a new basement on that. What is your intent that I'm going to do with that? Is that a new construction? Am I not allowed to add more than the 4% or 3%, whatever the is, if that basement even adds more? Because the footprint was already there, but we finished an added basement, or vice versa, we took it out. I just need guidance on what the intent is, and I need that kind of black and white, not.
I think Representative Locke has a follow-up.
Thank you, Mr. Chairman, and thank you. That actually helps me a lot. So is it safe to say that maybe even the guidance, the major improvement, or whatever terms we use, again, I'm sorry, I don't have it exactly. Is it safe to say that there's probably some clarification of that needs to go in place? Because my simple man's thinking was, if we made that explanation clear, that would help with that process. So is it safe to say that what we did in 45 could use clarification that would help with this? That's what it feels like to me, but I'm not sure I'm hearing that exactly. Thank you.
Mr. Chairman, Representative Locke, absolutely for most assessors, some clarity would help. And the specific example of the basement is one of those gray areas of how it's interpreted. Is it a structural change? Now, the department gave very good rules, and we're doing our best to follow those, but I'm not sure the laymen understand what we're doing with those rules. And so I do believe some clarity of what did you intend for it to be? When does that 4% stop? When is it no longer eligible? Is it when they significantly added an addition that added 50% to their square foot? That's easy to calculate. That's easy for everybody to comprehend. But the basement was there. It's always been there, but they just finished it. And in some cases, that's a significant value change for that property. Does that 4%, people are currently getting the break, they finished their basement in the year where the 4% cap applied. They only got taxed on 4% of that basement increase. The guy that did it the year before did not. Clarity would be helpful for us.
Ms. Huxtable, wouldn't it be easier just to, since we're almost up to the 6-year point now from 2019, to just, if the counties did the clawback to 2019, just leave it until somebody goes out there for the 6-year checkup and then adds in all the new improvements, and then we move forward from there?
Mr. Chairman, that is an option. However, we're rotating on that 6 years. So we've got property that went to last year. So it would be another 5 years for that property. So however you want us to do that, whatever you're thinking, make sure you have it very clear that it doesn't go into effect till the next reappraisal cycle or field check. And then, of course, there's some definition of that because some places have building permits. So we go out and pick up based on a building permit. Some areas don't have, and they're just on a regular review. So there's a lot of nuances, working parts on this. Just make sure that there's enough clarity that we can do what you want in a fair and equitable manner, please.
So the correct language would be a reassessment, if that's the way the body wants to go with
Mr.
that.
Chairman, I'm not sure of the exact language. Let me think about that, because it's a field check. It's a field review. It's not, we have to reappraise every year. By our rules in Wyoming, we appraise that value every year. So it's not a reappraisal, it's when we do a field review.
Okay, thank you. Representative Bear?
Thank you, Mr. Chairman. Assessor, it seems to me that if we were to define for you what a significant change on one of those field assessments is, say, as a percentage of the total value assessed, that would give you the clarity that you're looking for, that you could apply to any field assessments that happened during this period between 2019 and today, and going forward with any future field assessments that created an increase. So, for instance, the basement being finished, if we chose a number around 100% increase in the value of that home, and we said anything that percentage or greater would be a significant change, would that be sufficient clarity for your assessors to be able to make those kind of determinations, both in the past and going forward?
Representative Bear, that is certainly one of the problems with just the verbiage significant change, because that's open to interpretation. So if you make it clear enough with language that spells out what you define significant change to be, certainly that would be helpful. Not everybody's going to agree to it, but it would be helpful for us because, as I said, significant change is sort of an ambiguous word. My significant and your significant may be substantially different. So yes, if you could define it, that would be helpful.
Any more questions? All right, thank you, Ms. Huxtable. Is there any more public comment? All right. Okay, thank you. All right.
Got it. Good afternoon, Mr. Chairman, members of the Revenue Committee. I'm Pat Meyer, Park County Assessor, talking for the taxpayers in Park County. What I've given you is, on this first one, is what Arizona does of what you guys were just talking about. I'm talking about the inequities we're gonna have with 45 if we don't do something. Now, when we started looking at limitations and went through all the states, we only got excited when we found a state like Arizona who fixed the inequities of what Dixie was just talking about. This is what they do. When they go to limited tax value, we'd call it limited exempt value in Wyoming. But it's the same thing. We're trying to get to a different level, stopping the increases due to the fact that we lived off 3 to 5% increases for 30 years. Then we got that 2021 was the first year it really started, 21, 22, and 23. But let's go over the increases in Arizona. Nobody goes, you get a new purchase, there's no change to the taxable value, just to the market value. There's no change for the taxable value. When you have new construction, they use the ratio of the limited property value to the fair market value of similar properties to derive at a limited property value. So once you're doing limits in Arizona, they never get to fair market value when it's new construction, when it's a new purchase, when they add stuff. A sizable addition to the living room, it's calculated pretty much the same way as the new construction. You calculate the new limited property value using the ratio of limited property value to fair market value, or they use fair cash value, same thing, for a bigger house, like new construction does. So you're never going right to market value, so you're creating the same level of assessment. Instead of these new guys coming in, they don't get the exemption, so they go here, the same house will be down here, and if you keep doing this, this problem is gonna get really bad for you, for the inequities that are gonna happen on there. Now, of course, when you're using limited property value, you are gonna lose money, of course, and we'll go into the rollback too. Of course, if you roll back, you're gonna be losing money, but did you need it in the first place? Everybody finds it, and I'll go into that a little bit too. When a parcel splits, right now, if you split a parcel off and give it to your kid, you've changed your property and you're going right to market value. That doesn't happen in Arizona. They calculate the new limited property value using the ratio of limited property value to fair cash value of the original combined parcel, like new construction. Now, I made these easy because when you look at the rules in Arizona, it looks pretty complicated, So I just got some things out that we're having. That was a parcel combination. Now you got a bigger parcel if you did that. But if you were to do it today and you combine those parcels, you'd go right to market value. So you could do that 10 years later and market value could be huge above limited tax value or limited exempt value. Same when you split a parcel. Calculate the new limited property value for each split parcel using the same ratio of limited property value to fair cash value of the original full parcel. What we have with Arizona, and we have a good connection down there from a county over in Phoenix. His name is Brett McGee, and we talk on the phone a lot, so I can question him on how we could go into something like that and fix the inequities that will be coming on later on. Now, again, I would have went for limiting values if we didn't find the inequity problems that I'm talking about. But this could solve just what you were talking to the Converse County assessor about. This solves that problem. We can go into it more. Oh, by the way, I'm retiring at the end of December for all those who don't know. But anyways, and I mentioned that? No. No. If you look at the next page again, you've seen this before. We're going to talk a little bit about the rollback and where we are in Park County with it and what we've discovered and what can happen to it. But if you'll notice, you've seen this before, the median wage in Park County is the second highest medium tax bill in the state, $1,000 more than 15 of the other counties. If you go to the next page, I've highlighted anybody whose average and medium house is over 300,000. And there's really 8 counties, in my opinion, that would be looking at a rollback. I mean, the other ones, if you have a houses for $250,000, that's your average house, you're doing pretty good. You know, but our average house, when I look at just single-family resident houses with no townhouses and stuff, it's $479,000 now in Park County. So the damage was already done. The rollback seems to be the easiest way, and all the taxpayers seem to get it, you know? And when we're rolling back, what we do, it can't be done internally, you know? Assessors don't even have access to tables in CAMA, so we couldn't even look at it that way. But externally, it can. Now, we started with just doing the houses, but that doesn't work out too good because our land values went up so much on the test neighborhood we were doing. So now that you've got that going, we can roll back both the land and the improvements at the same time. Now I was almost ready to just start doing it, you know, because this would be the starting number. We're only going to have to do it one time. Once we've got that starting number, we're never having to do it again. And it is a lot of work, but it can be done. We can spot new construction from year to year. We pull them out, then we put them back in. We can find out big additions because we look at one year and the next year, if one of these went way up, we go in and take it. And we've always done that. We always run before and after to see what happened to that house and why did it go up so much more than the other one? Because they put a big addition on it or they added a garage and so forth. So there's outliers that you would actually have to manually most likely go into and fix, but a lot of it, it's gonna come right out. So we're having good luck with it. Like I said, we got test neighborhoods. We're gonna be running it, and then we're gonna change it back. And I believe on that other sheet was the same one on one Representative Locke has. That was what I showed you guys last time, along with the 4 examples. So what we're trying to do there is I'm showing you how it would affect Park County if we rolled back. Those would be the numbers. That would be the numbers there. we've got a little ways to go yet, but we could be ready anytime this legislation would decide on giving us the thing of rollback. And now you guys want to go to 2019, the base year. We've been rolling back from 2020, but we can easily change that if you guys want to keep with the 19. For the outbuildings, they're all done by cost. They don't go up like houses and so forth. It's just replacement costs, less depreciation. So they're rarely going to go up at all, 4%. And that way, if you got a new one, I mean, I'd probably leave those out of that. You know, don't worry about it. We got the land and the main improvement, and you don't need to mess with that. And that way, if they add a building, you got it. It's done on cost. It goes right to what the building was. So you wouldn't have that to deal with either. Like I said, we've got a good connection with in Arizona to help us through this. And they've got 23 pages of rules. They address a lot of other things that Wyoming's gonna have. And I mean, but we could address them. But those 5 I showed you is just a highlight of what we're gonna see a lot of, you know, splits and combos. And I mean, I'm trying not to go there. I would like to get the new owners, but man, the new owners could also be a young family that grew out of their house and they go to it. We don't want them paying that high fee when they had it down like that. So I know this is a lot to talk about right now. That's why I wanted to give you some visuals, and I can email you the rules. I just didn't have enough room to get any more of Arizona's rules. But a lot of them, if you want to go through them, they'd be good. I did want to show you a couple of other things. You already saw from the director the increases. They ran that page for me too, and I think. And then I looked at everybody's mill levies and what they do for the max, and I gave you a little bit of highlights of all of them. What I wanted to do is see, was everybody using their maximum mills? They are, mostly, you know, 90%. Everywhere you go, fire districts, they're allowed 3, they take the maximum, no matter what your values go up to. And you'll see that, and I did give you, you know, showed you where Park County's oil and gas and how we distribute it and who gets paid what for Park County. And then I gave you our mill levy report that State Board of Equalization ran on every county. So I looked at all of them, and I wanted to make sure there was, you know, now there are some that get to drop their mills, but they don't, you'll see how much they dropped them on each one of those. I've highlighted them for you, and you can always go get this from the State Board of Equalization for your own county, if you wanted to see what was going on and who's taking the max. I know in Park County, you'll see that the cemetery districts don't take their max anymore. But they do take around $825,000, you know, that's pretty good for it only taking $1.5 million. You know, that's a lot of money, but I think, Mr. Chairman, when Senator French was in office, I think they questioned the cemetery districts. And all of a sudden, they quit taking their max, because at one time, they'd take it all too. So, I mean, but they don't have any control over hospital districts, fire districts, cemetery districts. They all have their own boards. And as long as they don't take more than they need, they get to do that, you know? So I do believe rolling back for Park County is our answer, doing the 4% a year. It is hard. We know how to do it, but I don't know how long it will take, but I mean, well, a few months, I'm sure, but it would still be the starting point. I'd like to do it this year. I wasn't sure I couldn't do it, because I'd be still valuing everybody fair and giving them all the exemption that they would have got anyway this year. I don't know why I couldn't do it if the county commissioners agreed to let us go, and I don't want to wait, well, I don't want to wait till 2026. I'd like to get her done, but my staff's all been working on it with me, so it's not like that's going away. With that, I know it's a lot to take in, you know, but let me answer any questions you may have. And when I am gone, if you need Park County, I hope to get my first deputy appointed for county assessor, and he'll be very helpful for you too. And then I hope we can show some other assessors that want to roll back what we've been doing and what we've been testing on, if that's what they want to do as well. I'm sure Sheridan County would probably be considering it because they have the same problems we do. And it would be a fix, but you've seen how much money we'll lose. But if you look at that page, you'll also see the highest we were at were 10 million. And when we rolled back, we'd still be at the 10 million with the rollback, just not at the 12 million that we have now and spent, you know, so.
Thank you, Assessor Meyer. Senator French has a question for you.
Okay.
Thank you, Mr. Chairman. Assessor Meyer, I've got so many numbers and figures in my brain this morning that, would you simplify this for me, please? If we roll back, let's say my house is $300,000 assessed value in 19.
Okay.
And I do nothing to it and goes along, and then I think in Park County it jumped 10%, and then 21, and then 18, and then this 4 or something like that, or 6, whatever it is. Walk me through that. So if we go back and that house is 300,000, and we go along and suddenly with all those jumps in our county, it's whatever, 400, 450,000, whatever. How does this rollback apply to that number of 300,000?
Okay, Mr. Chairman, Senator French, what we're saying is whatever that value was in 2019, before these increases, we would be going up 4% a year. And if you look at your house on that, what I gave you, your house is there. It's 4% that year. You have a new number. We'd go to the next year, you'd get another 4%. Instead of that, 23%, which was the killer. And the next year too. So then we'd have you in 2025 at a whole new starting point, which is on that sheet for your house. You know, one year you didn't go up. So, you know, then nothing would happen. But we would do the 4%, replacing that 23% and the 18%. That's what a rollback is. And we've already learned how to take out all new construction and then re-enter it in for the next year because it wasn't there the year before. So with the present rules, he goes right to market value. I'd like to change that, or at least have you guys discuss that for the inequities, which even the State Board of Equalization recognizes too, that we didn't want that to happen. And like I said, I would have quit looking into limits if I hadn't found this and talked to Arizona about it.
Yep. Co-Chairman Hirschman.
Assessor, how many years have you been the assessor?
Years I've been the assessor
many
is
years?
14 years in the assessor's office, 39.
Wow.
First deputy for 20.
Appreciate all your good years
Yeah.
of service. Well done, man.
Yeah,
Appreciate you.
yeah.
Thank you.
Yeah.
It's a lifetime of work. Appreciate it.
Do Senator Ide and then Representative Block.
Thank you, Mr. Chairman. Assessor Meyer, I just want to tell you that I appreciate your can-do attitude to work for your property owners up there. We don't get a lot of that. It's usually the other way around. So kudos to you for coming here, taking the time, giving us this information, looking for other states that have accomplished this, and that shows a lot of character. I like that. You made one comment that you could do this tomorrow if your county assessors would allow you to. If we change the language of this bill from may to shall, I think that would accomplish that, and then you wouldn't have to ask for permission to do that. Would you agree with that? Thank you.
Mr. Chairman, Senator Ide, I think there's too much money to be lost for me to make that decision. You're not going to get as much money. We would have been doing just fine if we didn't have those increases. But I think that's gotta go to the county commissioners and got to them explain, because they want, I don't know if they'll do this. And I don't know if I can't really say for other counties that everybody should roll back. I don't know. I mean, we don't have it down pat right now where it's going to be an easy thing. I think it's a little more once I get going more on it. We're still in the test mode. When we really find some good answers and solve any kind of problems, which I think can be solved. But if I stick with the same thing, whenever you get a new purchase or whenever you split, you go right to market value. That's what we're doing in the test right now. I'm following the rules that we have. So I'd like to see this change, and I'd hope that we can get some cooperation and work on this.
On that, Co-Chairman Harshman.
Thanks, Mr. Co-Chair. Assessor, just kind of, just wondering really about constitutional issues, kind of this whole uniformity statewide, and then how, where it's the state's wealth. It's not local wealth that funds schools, and how that, so then all of a sudden you have these areas that, well, we're going to contribute less of our state wealth to that. Is there some issues out there you maybe think you see?
Well, Mr. Chairman, I think there was some issues on 45 to begin with. As you know, my bill was to change the Constitution. I wanted it to be able to say limited tax value. Well, we didn't do that, which was good because it didn't even make introduction. If you remember, it needed 2/3. So we wouldn't have had that option until 2026 anyways. So I'm taking 45 and doing the best with it. You're calling it an exemption. I don't think that hurts the Constitution. We can do that. We can still make it equitable and so forth because it's a limited tax exemption. I don't see why we can't keep calling it that and not worry about the Constitution. We're still showing market value. We're just showing limited exemption value too, to get through that. And I think you can do it. You did it to 45, you got it, you stopped the increases. It's just some of us got hit so much, we stopped it too late. If we would have had it all the time, and I was for 5%, but I know other states do just what you guys are doing, the 3% or whatever less of the consumer report. So that is being done, it's not like it. I just kind of like the 5%, and then when it went 4%, I was fine with that too, but I don't know. I'd give myself a room on the limitations, because what if you do need money? Can you raise that limitation up? If all of a sudden markets got really bad, can you raise that up to get there? I mean, I'd be giving you, the hardest thing I think is we're trying to do things for the whole state when we are so diverse. As you'll see in there, I mean, one county's got $52 million, just the county budget. The two adjoining counties work under $3 million for those counties. So, our tax bill, so we're not going to be ever fair and equal between the counties. You got to work on uniformity and stuff just in your county. And if everybody's at market value and doing their job, that's as uniform as you're ever going to get. Because you got 23 different assessors, and even the cost systems have different multipliers depending on where you are. So none of the counties are going to be alike. So We work to get the fair market value, and I believe more importantly is the fair and equal, treating everybody the same. And that's never going off limited tax value under the grounds. And we stopped government spending, which is all the conservatives were looking for, right? Stopping government limits stopped government spending, because we proved even if we got an extra 2 million, we'll find something to do with it, instead of what, on behalf of the county commissioners though, with the smaller counties, you gotta save your money more. You know, you can't just buy. The bigger counties, they can get stuff done, the mineral counties, they can get stuff done right away. So.
Can I, while you're thinking Arizona, Mr. Co-Chair, just to wrap up on my questions, what is Arizona's cap? It's not, is it 5 or 5.5?
Arizona's cap was 10. In 2015, it went down to 5, and that's where it remains now.
Okay, all right, thank you.
Representative Locke.
Thank you, Mr. Chairman, and thank you for bringing this data. This is really good, but this is just a quick clarification point. Hopefully it doesn't take too much. So if I understand Arizona's approach correctly, they picked a point in time, whatever that was, and they baselined on whether it was fair market value at that point in time or whatever. They baselined, and then they applied the cap, and then from then on, everything, including new construction, gets calculated against that capped baseline. Is that basically right?
Pretty much, yes.
Perfect, thank you.
Pretty much. Now, they didn't have to roll back when they did it. You know, they did it a long time ago. They didn't have to roll back. They weren't into our problems, and they've had it for quite a while now. You know, the 10%, and then they lowered it to 5 in 2015, which you'll see in those rules, Mr. Chairman, what they did there. But you'll also see they're kind of hard to figure out until you really got to look at it. But it's a little easier for us because we're used to this type of thing. You know, we've been looking at it for a while.
All right, any more questions for Mr. Meyer? Seeing none, thank you, sir.
Okay.
Appreciate it. Thank you. Any further public comment on working draft 166? Is there anybody on Zoom, Eve? Nobody on Zoom. Okay, we'll close public comment. Committee, what's your pleasure? It's been moved by French, seconded by Locke. Any discussion? Any amendments? Senator Ide?
Thank you, Mr. Chairman. I would like to make a motion to amend anywhere where it says may to change it to the word shall when we're referring to Board of County Commissioners shall adopt a resolution.
Okay. Is there a second? Seconded, okay. Discussion? Representative Bear?
Thank you, Mr. Chairman. It's my understanding that, we have our tax exemption and rollback. We don't have a rollback. And I do agree with this motion to amend that we have a rollback for the whole state, not the county commissioners. But I'm just curious, and maybe we have to have somebody come back up and tell us, if we were to make this for the whole state, eliminate the county commissioners in this approval process, would we be putting undue pressure on the counties from the state level, I guess is the question. Actually, the way I want to phrase that question is, does it affect the county optional program? That's what I want to know. Does it affect the county optional program if we don't do the clawback by county, but do it statewide?
Is that a question for Josh?
I'm not sure I fully understand the question, Mr. Chairman. I think if you were going to make this mandatory, I think you could take the county commissioners out of it and just say this exemption shall be administered as if it was in place in 2020 and then go on from there. I'm not sure I understand the question about what the county optional program is.
Do you want to clarify the county option? No, I think I did. Okay, all right. Senator Ide.
Thank you, Mr. Chairman. I think what Josh just referenced there, I would like to amend my amendment and just take out the county commissioners like he suggested. I think that's a cleaner way to go about it.
But are you following this, Josh? Does that make sense?
Yeah, Mr. Chairman, so I think it would be there's two places, but instead of saying Board of County Commissioners may adopt a resolution, we delete all that, and then it would just say, like page 3, line 13, it would just start, the exemption under this paragraph shall be administered as if the exemption was in place beginning tax year 2020.
Okay. All right. Any more discussion on the Ide amendment? See none. Call the question. All those in favor say aye.
Aye.
All those opposed? Okay, that amendment's been adopted. Are there any other amendments? Representative Zwanitzer has one.
Thank you, Mr. Chairman. I guess I'd like to make an amendment to change the 3% to 4% on the two places, primarily line 4, or page 4, line 27. It just seems odd to me that we would say, well, it's 3% from 2019 until 2023, and then it turned into a 4%. And so I guess I'd like consistency and make it 4% across the board would be my motion.
Okay. Seconded by Oakley. Discussion? None? All those in favor say aye. Aye. All those opposed?
No.
Chair's in doubt. All those in favor, raise your hand. 1, 2, 3, 4, 5, 6, 7. Okay. All those opposed? 7. Okay. That fails. Any other amendments? Mr. Co-Chairman.
On page 3, on those lines 6 through 9, we had that discussion about, brought to us by the assessor on these outbuildings, and just simply leave, I think what Representative Locke said, just kind of that detached garage part, that what's the difference between an attached and detached garage? And so kind of clean up that language, get rid of all that other language so we don't have any confusion on that, and just have including a detached garage.
Okay. Would you want to include that is not used for commercial, industrial?
Right, I
ag,
think
or-
that stays in there, and that's fine. I think that's,
Okay.
you know,
All right. Is there a second? Seconded by Oakley. Discussion? Seeing none. All those in favor say aye. Aye. All those opposed? Okay, that has been adopted. Any more amendments? Seeing none. Eve, would you please call the roll?
This is a roll call vote for 25 LSO 166, property tax exemption for residential property revisions as amended. Senator French,
Aye.
Senator Ide,
Aye.
Senator McEwen,
Aye.
Senator Pappas,
No.
Representative Bear,
Aye.
Representative Byron,
No.
Representative Locke,
Aye.
Representative Northrup,
No.
Representative Oakley. No. Representative Storer,
No.
Representative Strzok,
Aye.
Representative Zwanitzer. No. Co-Chairman Harshman,
no.
Chairman Beitman.
Aye.
Seven ayes, 7-0.
All right. That bill draft has not been adopted. And that gets us right till 12:03, so we'll go ahead and take our lunch break now. We'll recess for, anything, Mr. Co-Chair, an hour and 15, something like that? Do an hour and 15-minute lunch break, and we'll be back to take up the rest of these bills.